fearless, resilient, diverse. This is Rochester. A city, a people, welcoming and driving change. Our culture of adaptability and innovation makes Rochester truly different. These traits were the foundation of our city's creation and are the center of its continued rebirth. And it's why Rochester is a great investment. We are the city of visionaries and leaders like Frederick Douglass, Susan B. Anthony, George Eastman, and Joseph C. Wilson. Rochester's culture of innovation and risk-taking won wars, invented industries, and without a doubt, completely changed the future of our nation. Our story is also your story. Rochester continues to be the city of innovators and strivers. You saw opportunities, created a vision, and worked tirelessly to make it reality. Our city embraces your vision. We're grateful for the risk you are taking, and we share your faith in our community. I know that together, our city will reach even higher, and that together, we'll build a better, stronger Rochester.
Good afternoon, everyone, and thank you all for joining us today at our second annual Landlord Summit. My name is Gary Kirkmer. I'm the Commissioner of Neighborhood and Business Development with the City of Rochester. Before I go any further, I want to recognize the elected officials joining us today. We have Council Vice President Lightfoot and Council Members Patterson and Ortiz. I want to thank all our presenters and panelists for taking time out of their busy schedules. Their expertise is unparalleled and very important to this event. I want to thank our behind the scenes MBD team, our staff, Ann DeSilvatella, Henry Fitz, and Jill Simons for putting this together despite the pandemic related obstacles. Without them, this simply would not have been possible. Events like this show both our commitment to you, our landlords and property managers, and your commitment to the business of providing safe and habitable housing to our residents. We wanted to build off of the successful event we had last year. Despite having to hold this event virtually, we believe you'll find it to be a valuable use of your time. The work that each of you do is extremely important, and the purpose of this event is to keep you informed and to provide you with information needed to run a successful business. In this city, we pride ourselves in being advocates for responsible tenants and partners with responsible landlords. This is clearly reflected in our policies and procedures. We are here to work with you. We are convening this forum to further the conversation about how you can navigate through these difficult times to get a better outcome for both you and your tenants. Here's a quick overview of today's program. We're going to begin with a short presentation of the early findings from a COVID landlord survey to be presented by our partners at the Ash Center at Harvard University. Following that, you'll receive an overview of the new eviction laws and updates on the COVID eviction moratorium. These are very important topics that impact your business significantly, so we have convened experts from the Housing Council, Monroe County DHS, the Legal Aid Society, and an attorney from Boylan Code to delve a little deeper into some of the new laws and COVID-19 related issues as they pertain to your business. After the panel discussion, I will return with my colleague Kurt Martin to give us some city updates and highlights as they pertain to city-specific programs, inspection protocols, and other updates we believe you will find useful. At the conclusion of that, we've set some time aside for question and answer, both for the topics we're going to discuss today and for any other questions you may have. If we don't get to all your questions today, we plan on publishing a Q&A document after the event, so please check back on the city's website about a week after the event. Finally, we would love to get your feedback on this event and a number of other topics. Throughout the event, we will use short polls, quick questions, and we would appreciate your feedback to help us better programs for both you and the tenants we serve. With that, I'm going to pass things off to Henry Fitz. Henry's going to be our MC today and keeping us on time as we move through various subjects. He'll begin with a few housekeeping items he needs to share with you.
Thanks, Gary. Everybody, we're really glad to have you here and, making use of some new technology tools that has been maybe a happy spot with the COVID pandemic that we know has been a struggle for everyone. So I have a few housekeeping items related to use of Zoom and how we're going to be interacting with you today. So we have over 450 people signed up to join this event today. And just with the volume of people, we decided to disable video and chat for all the attendees. And we'll be taking questions only in written format. So please use the Q&A function down at the bottom of your Zoom screen to submit written questions. We have my colleague Jill will be monitoring that, and she's going to be summarizing and feeding those questions back to us panelists so we can go through them in a logical, expeditious way and reduce duplicative questions. In addition, please use the options at the top of your screen at the top right to change the view options. You may want to pin a particular panelist if you're interested, or use some of the other functions. So explore those if you're interested. Finally, a couple of final items. The recording of this and the slides will be posted on our webpage for the event, cityofrochester.gov/Landlord Summit next week. So you'll be able to check those and share those with anybody who couldn't make it. And finally, as Gary mentioned, we'll be using polls throughout the event to hopefully keep things fun and interactive. So we're going to do a quick test right now of our first poll. And Jill's going to launch our poll, and you should see a pop-up on your screen. You can respond to that. So far, coffee is a big leader, 66%. All right, I think we got the gist of the polling function. We'll do this on some other actual topics later on in the summit agenda. You can see the results also popped up here on your screen that we're sharing with you. Great. All right, with that, we're going to get into our lengthy agenda. I'll be your MC and hopefully keeping us on track and on time as we move through what should be a very densely packed set of information, but hopefully very helpful for you. Oh, quickly, before I get even into that, I wanted to give you a quick summary of who's on the call today. So we have, like I said, over 450 attendees. Of those, 366 plus are landlords, representing over 7,000 units in the city of Rochester. About 83% of those landlords are local to the Rochester area. The remainder are dispersed throughout the country, and we even have a few from outside the US. So thank you for everyone far and wide for tuning in. All right, our first major agenda point, I'd like to welcome Elijah De La Campa and Snapper Poche to discuss findings from a survey that we helped conduct that many of you may have responded to, and some of the early findings from that survey that they can share with us today to help inform the evolving situation. Elijah?
Thanks so much, Henry. So good afternoon, everyone. Thanks, thank you so much for inviting me, and I'm so excited to see so many participants, even if I'm just looking at little names on a Zoom chat screen, but it's great to see so many folks have joined us this afternoon. So my name is Elijah De La Campa. I am a senior research associate with the Bloomberg Harvard City Leadership Initiative based out of the Harvard Kennedy School. Today I'm going to be talking about some preliminary findings from the Rochester COVID-19 Landlord Survey. Before I get into that, just a big thank you to Mayor Warren and Commissioner Kirkmeyer for inviting me to speak this afternoon. A big thank you to Henry and Jill for all of their hard work in putting together such a great agenda and summit for us. But most of all, a big thank you to all of you landlords for joining us today and for your continued investment in the city. So next slide, Henry. Okay, so you all know better than I that COVID has really flipped the rental business on its head these past few months. So I'm not, I don't need to tell you that today, but what I do hope to tell you and show you is using this COVID-19 survey that we launched with the city's aid, we can really start to think about how big this problem really is. What is the scope and what's the magnitude of it? And for those of you who may not have received the survey or may not be familiar, what we did was we worked with Henry and folks in the Department of Neighborhood and Business Development to field this survey to a pool of smaller landlords in the city of Rochester. So landlords who own, say, 3 or fewer properties was our target. And we asked landlords questions for each property that they own. How much rental revenue did that property bring in the month of June 2020? And what steps have you taken in response to decreased revenue? And also some basic demographic questions. So overall, just how many people did we invite to the survey? That was around 2,271. And 285 of you responded to the survey, actually completed the survey, around a 12.5% response rate. And what we can do with that information is do some fancy statistical techniques, which is kind of my area of expertise, to make these surveys findings really generalizable and representative to the city overall, in particular to the pool of smaller landlords in the city of Rochester, those who own around 3 or fewer properties. So the overall sort of sample of properties that we are able to generalize our findings to is around 10,000. So keep that number in mind, around 10,000 properties. That's a little over a third, according to my calculations, of rental properties in the city overall. So getting into some of the meat of the findings, what we find is that 3,770, next slide, yeah. 3,770 properties, previous slide, Henry, sorry.
Oh, sorry.
No worries. 3,770 of those properties report not receiving the full amount of rent by June 15th for the month of June 2020. So that's around 40% of all properties that we are able to generalize our findings to, right? So what we would like to do maybe is think about that on a per unit basis. And one way to do that is just multiply that figure by the average number of units per property in Rochester, which is just under 2. So we see that 6,300 units is a pretty good estimate of, say, of these, for these small landlords, how many properties are behind in rental revenue. We could do that a slightly different way and get a number around closer to 9,000 units behind in rental revenue. But what we can do with these unit numbers, the reason I'm going through that is because we also know, what is the average amount that properties are taking in our sample. And what we see is that number as a percent of all rental revenue that property generates is actually in the range of 75 to 89%. So properties are just not taking in the full amount of revenue that they normally generate. And with our sort of calculation of the number of units behind and how much rental revenue they take in, we can really start to sort of understand how big is this problem in dollar terms. And what we did is just sort of estimated a lower bound on that and an upper bound on that. And the lower bound is around $2.7 million and the upper bound around $4.6 million just for the month of June 2020, just for this sample of smaller landlords in the city of Rochester, around 10,000 rental properties. So, we understand that you're hurting. These numbers are big any way you slice it. And this is just 1 month that we're really looking at. So next slide, Henry. Another way to look at this that is particularly interesting is just comparing it to last year, right? We're in the middle of the pandemic now in June 2020. What does it look like? What does rent look like in a typical month in the city of Rochester? So what we did in this graph is just graph 2019 versus 2020. 2019 are bars shown in green. 2020 are bars shown in red. So things that are shaded brown indicate an overlap between the two. And what I'm doing is just looking at the proportion of properties, how much money are they bringing in as a percentage of the total rent that they normally generate. So looking all the way on this rightmost column, what we see is that in 2019, the properties were bringing in, over 80% of properties brought in 100% of the rental revenue that they generate. So people were paying their rent. 82% of the time, people were paying their rent in full in the city of Rochester. In 2020, by June 15th, that number was down to 60%. So that's a 25% decrease in the amount of in the amount of properties taking in all of their rental revenue, right? And just looking at the leftmost columns in this graph now, what we see is happening instead is that properties are much more likely to be generating 0% in rental revenue. So that no units are just not paying any rent at all. And also much more likely to be getting less than 50% in rental revenue. So a very small proportion of what rent actually is. And again, this is by June 15th. So perhaps money is trickling in later in the month, but these findings are pretty stark, a 25% decrease relative to the prior year. So next slide, Henry. So the purpose of these slides, I just break this rental proportion of rent taken in data a couple different ways. And the point really is just to show that, no property type, no landlord type is immune to the effects of this pandemic. So what I've done is I've just broken out this figure by the property type, by the most common rental property types in the city: apartments, single family, 2-family, 3-family. And you see across the board here, looking at 2019 versus 2020, properties are taking in less rental revenue in 2020 relative to the prior year. And oftentimes, looking at single families, 2-families, 3-families in particular, the most common rental property types in the city, they're much more likely to be taking in 0% in rental revenue or less than 50%. So just a small fraction of what rental revenue actually looks like for those properties. Next slide, Henry. And then this one is just to show just by the number of properties owned, right? Because we're focused on smaller landlords. So of course we assume that, we don't assume necessarily, but of course we imagine that these problems are just as stark for large landlords, but our sample allows us to talk about the smaller landlords. And we see that no matter how many properties you own, again, this pattern seems to be consistent. Just looking at 2019 versus 2020, you are much less likely to have your to be capturing the full amount of rent from your rental property, much more likely to be taking in a smaller number. And then next slide, just the last thing I want to show. Another interesting way to look at this is just, by where the properties are located in the city, right? So what I do is I just divide neighborhoods by basically their median income. Was that property located in a neighborhood that is below median income or above median income for the city overall? And we see properties located in low income and properties located in high income neighborhoods just very likely to much less likely to be taking in full rent for June 2020. And the interesting bit here just to highlight is that properties located in high income zip codes actually experienced a larger relative decrease from 2019 in terms of the taking in 100% of rent. So that was about a 35% decrease for high income zip codes. It's about 20% for low income. But again, the story is that all properties are much more likely to be taking in 0% or less than 50% in rental revenue. And our hope today really was just to show you, we understand that this is a big problem. We see that you're so much more likely to be taking in, a very small fraction of your rental revenue. And our hope is that putting some parameters on the size of it and on the scope of it is just really the first step in figuring out how to actually solve it and move forward in a productive way. So I think I hit my 10 minutes. Thank you all so much for listening. And please put in any questions to the Q&A and I'll be happy to answer them later.
Elijah, can you just tell them what your plan is in terms of actually publishing the results?
Yes, great question as well. So yeah, we're still working on sort of putting together a full package. We also, one thing I didn't mention is we fielded the survey in Albany as well. So, we're working to sort of, look at the findings across the two cities, see what they look like, see how they compare, and then sort of hopefully publish a working paper with perhaps one of the housing centers at Harvard, and then push this out, for an academic publication. But of course, as well, keep you all informed, because our primary concern is making sure you all know this information so that we can chart a path forward.
Great. Thank you, Elijah.
Thank you, Henry.
All right, we're just going to do a quick pop-up poll, reactions to what you just heard from Elijah. Jill's going to launch that poll. We're also going to switch the default view to gallery mode. I think we just got some comments that would be helpful. So far, 85% people say this is consistent with what their experience is. Great. Well, we've got 70% in. I think we'll call it. Overall, 82% of landlords are experiencing consistent with what the survey showed. So we definitely understand and are, from a variety of different mechanisms, collecting as much information as we can about the situation as it continues to develop. And this is going to help inform how the city and partners respond to helping you and tenants through this crisis. All right, next up, I'd like to welcome Mark Muyo, who is the Program Director for the Housing and Consumer Law Unit at the Legal Aid Society of Rochester. He's going to give us a brief overview of the new eviction laws that were implemented in late 2019, as well as how those interplay with the COVID moratorium that has been in effect, barring evictions.
Yes, thank you very much, Henry. This is Mark Moyle from the Legal Aid Society of Rochester. I want to start out by saying, because I'm an attorney speaking to a large group of people, that by speaking here, I'm not creating an attorney-client relationship, and I'm just giving general information the best that I can. So please don't take it as legal advice. That's just something attorneys have to say when they're speaking to a large group. We can go to the next slide, I think, Henry.
Great.
Okay, so as of June 2019, landlord-tenant relationships in New York were, I'm sure everybody on this call is aware, were rearranged in certain ways. The main issues that I would point out, the first is that timelines were changed. So this is a flow chart of how the timelines have changed. This is the eviction process. In 2018, there was a time that you had to give your tenant to pay the rent. It was a demand for rent or a 3-day notice to pay or quit. And then after that time expired, you could file an eviction, and then you'd have to serve it within no less than 5 days and no more than 12 days. And then there'd be a hearing, which would either turn into a larger hearing where facts would be found or an agreement would be put on the record, or the judge would make a decision that day. And then a warrant could be issued. Everybody knows that the old warrant was a 72-hour warrant, not including weekends and holidays. And so the process could actually go quite fast. If somebody didn't pay rent on the 1st of the month, I saw people evicted around the 20th, sometimes of that same month. Not very often, but sometimes. So that was a case where if the landlord acted very quickly, that an eviction could happen within the month where the rent was first not paid. Henry, I think we can go to the next slide.
Yep.
Right, so this is the eviction process. Now, instead of the notice to pay or quit being 3 days or immediately if it's in person, then now it's 14 days and it must be written. So that's a 14-day period. And that comes after an overdue period of 5 days. So people are given a grace period of 5 days. Personally, I think there's some ambiguity in the law regarding the 5 days. And I think most lawyers who've read it recognize that. But if you're going to be on the safe side, I think you're going to give the tenants the 5-day grace period before you issue the 14-day notice. That's what I've heard from attorneys who represent landlords. After the 14-day notice expires, then you can file in Rochester City Court or in one of the town or village courts, depending on where your property is located. And they changed the timeline for service. So there's no fewer than 10 days and no more than 17 days before the return date in court. So as you can see, even by this, we're already outside of the month where rent was initially due. We're into the next month in essence. If we add 5 to 14 to 10 to 17, we're almost outside of that month. Now the timelines have been expanded also in court. So there's an initial hearing. And if there's a fact that needs to be found, or an adjournment, and in the judge's discretion, an adjournment for something important like maybe counsel to represent the tenant, that adjournment can't be any shorter than 14 days. So that's basically a time to come together and try and work the case out between the two parties, or for the tenant to find the documents that they need to produce to make their case. And then the same thing is true for the landlord. After 14 days, then a trial could be held. The judge would make a decision. If the judge decided that a warrant of eviction was to be issued, then that's now not a 72-hour warrant, but a 14-day warrant. And depending on the type of case, I think over 90% of the cases in Rochester City Court are non-payment cases. So up until the very last day of lockout, the tenant has the ability to redeem the property, which means to pay all that is due so that they can stay in the property. So that what this has really done is extended the timelines for people who are alleged to be in breach of their contract to make good on that contract and to not be put out in that way. And if anyone's familiar with the way that foreclosures work, that's exactly how foreclosures work. You can file a bankruptcy up until the moment that it's struck down at an auction. And then similarly, you can redeem up until that day as well, up until the moment it's struck down at an auction. So this brings that into a similar principled line, not a same timeline, but the line of in line with the same principles of redeeming the property before possession is lost. And there are, thank you, Henry. There are little nuances to all of this. So I don't want to be speaking as an absolute authority on this, because a lot of this has not been litigated in appeals courts. So let's say for instance that the tenant pays the full judgment, but a new month has come due before an eviction happens. Then you would have to actually go back to court and find out how much money is due. So that's one part of the law that isn't discussed very often, that there's meant to be a new hearing to find out how much rent is actually due if someone is trying to redeem. So again, there are nuances within huge parts of this law that just have not been put through the appellate process yet. So I'm trying to just outline it in the most general way possible. Okay, Henry, thank you. Okay, so now we are into the COVID moratorium. Now, I like to look at these issues from the top down, and in general, the level of importance would start at the federal government, it would go down to the governor, and then it goes down to localities, because county executives and mayors have certain abilities, but in this case, what we're dealing with is something in between those two, and that's an administrative order from Judge Lawrence Marks, who is the Chief Administrative Judge of New York State. Here is where we currently sit. Any cases that were filed before March 17th, 2020 are suspended right now, but they are required to be conferenced. So they're going to be conferenced starting, if you're in the city of Rochester, starting September 1st, and the judges don't know how long they're going to take to conference. There are approximately 500 cases to conference. So we're thinking that that's probably, let's say, going to take the month of September. I don't have the exact dates, but let's say it takes between 3 and 4 weeks. Those cases are going to be conferenced. That will bring us to the time where Judge Marks has, at least at this point, stated that warrants of eviction can, let's say, be executed, which is after 10/1, October 1st, 2020. So the judges in the court is trying to follow the the administrative order as best they can. And then once new rules or new orders come out, we're going to try and take those into account too. And just nobody's doing this without consultation. So I'm in plenty of meetings where the judges and court staff are meeting with attorneys who represent tenants, who represent landlords, DHS is in a lot of our meetings. Other community organizations who are helping in terms of finances are involved in these meetings. So this isn't just one person making a statement and then things coming through. It's a huge collective process where we're trying to talk about capacity in terms of human beings and capacity in terms of finances, and trying to do our best with what this pandemic has thrown at us as a community. So I just wanted to just make that little aside, that this isn't just one or two people making decisions. It's a people with all sorts of stakes in the community making collective decisions the best that we can. I think we can go to the next one, Henry, if that's possible.
Yep.
Okay. Actually, okay, you can go back. I have one more thing to talk about that there's not a slide about, but one thing that's been coming up recently, and it's more of a fear than it is an actual huge, massive problem. I do get calls about this maybe 3 or 4 times a week, but we're talking about illegal eviction for a moment. So illegal eviction is when, without a court's order, whether it's from eviction court or from Supreme Court, county court, or sometimes family court, no person can be removed, locked out, or threatened with such. And that can include also, let's say, messing with people's utilities to try and force them out, or taking the door off, or changing the locks and not providing a key. That, in the new law that was passed in June 2019, is now each of those offenses, even the threatening, the turning off of utilities, and then locking out or removing the door, each of those is a Class A misdemeanor. And as maybe some people are aware, in the past, the police might show up to something like that and say, this is a civil matter, we're not getting involved. My advocacy at this point has been, this is now a criminal matter, and the police can be involved. So we're working that out. I know it's over a year old, and we're still trying to work out some of the kinks with the police and with the DA's office. But I mean, I'm just going to sit here and recommend that people don't do that, given that it is a crime.
Great, thank you, Mark. So I'll have now Mark join our esteemed panelists here, and I'll ask them each to introduce themselves in a minute. But just a reminder, we're going to go through a list of prepared questions that we created for the panel. We are also collecting written questions through the Q&A function. My colleague Jill is reviewing those and she's feeding them to us. If she dismisses your question, please don't take that as that we are not going to answer it. That's just a tool she's using to track the questions. So she may be actually combining your question with somebody else's that was similar in that case. So with that, I'd like to welcome our panelists. Please turn on your video and unmute yourself. And our first question includes introducing yourself. So I'll have Jamie go first.
Hi, everybody. I'm Jamie Michelle Keene. I am a real estate partner with the law firm of Boyle & Code. I am also, as of last year, after the passage of the HSTPA, a co-coalition leader of an organization that we formed called Under One Roof. It is a coalition that's somewhat unique in that it represents landlords as well as tenants. And our mission is to try and work together to make the experience of renting property better for all involved.
Great. And Jamie, how are you working to help prepare us for the COVID moratorium lift?
So what I've done in COVID is I have a daily roundtable that runs at 2 o'clock every day. It is in email necessary, invite only. So if anyone is interested, I would need emails. But we have been having anywhere from 95 to 120 on the high end, and regularly around the 45 to 65 people every single day, digesting where the governor's executive orders are. And so making sure that the landlords have up-to-date information as a resource, because there isn't really landlord associations. There's, subgroups that meet, but they're not very big in capacity usually, and not many lawyers are engaging in the landlord tenant realm. So we felt it was necessary to find a space where people could come get accurate information, up-to-date information, and things like knowing they can't lock out their tenants, and to foster communication and ways of alternative arrangements with the tenants, so that the goal would be to keep the tenant in the property and work out an arrangement where the landlord can get the rent, understanding the difficulties of COVID right now.
Fantastic. Great. Next up, I'll ask Mary Leo to introduce herself and what her organization is doing.
Hi, good afternoon, everyone. My name is Mary Leo. I'm the Executive Director of the Housing Council at Passstone. I hope many of you are familiar with the Housing Council at Passstone. I transitioned into the Executive Director position in June, so right when all this was happening. I can tell you that at the Housing Council, we have been HUD's largest approved housing counseling agency for many years, but with everything that's happened with COVID, we've adjusted the way we do that work. So to be a HUD certified housing counseling agency, it's our role in the community to take an unbiased approach to educate all spectrums of the housing realm, whether you're looking to be a first-time home buyer, you already own a property and might have some issues with the mortgage or taxes, you're a tenant trying to navigate moving or your rights, and then we are the only local agency that's providing workshops and ongoing education and support for landlords. So you can imagine that we've really revamped the way we do that to both be up to date. Part of that is sitting in on Jamie's daily roundtables. We appreciate those. And then working with the partners on this panel to make sure that we're providing our community of landlords accurate information at our virtual operating rental properties courses. And since COVID, we've added on some 1-hour sessions that are topic specific to keep up to date with what's happening and everything that's been changing. So as the executive director, I'm here to take back some feedback to my team on how we can continue to better serve you, but then also feed down some of the information that we're learning from our partners on the resources available to the community locally.
Great, thank you, Mary. Next up, I'd like to ask Denise Reed to introduce herself and her organization.
Good afternoon, everybody. My name is Denise Reed. I am the Director of Financial Assistance at the Monroe County Department of Human Services. At the Department of Human Services, we provide financial support for low-income individuals in the County of Monroe who need assistance. They either have low income or no income, and we provide financial assistance that would be used to pay their rent for individuals that are both financially eligible and programmatically eligible for assistance. We have about 9,000 active public assistance cases right now, of which you may receive direct rent payment, or the person may receive the rent directly to themselves and then be responsible to pay you. And as we prepare for COVID and the lifting of the eviction moratorium, we are gearing up to see what we anticipate to be large numbers of individuals applying for public assistance. Since March, though, we have been encouraging people to apply for assistance now and not wait, trying to enforce the idea that even though there's a moratorium, rent is still due, and that if individuals were eligible for public assistance, having them come in and apply. We had some information stuffed into food link boxes that went out to households so that they would know that we were open. We've never been closed during the pandemic. We were always open for applications, and I think that was some confusion. People didn't come at first; they thought we were closed, but we've always been open and processing cases, getting rent out to people, to landlords for individuals that are eligible. And we're preparing again to work with all the partners on this call with the court to try to issue benefits whenever possible to prevent evictions and keep people housed. And I guess we'll talk a little more later, I think Mark will, about some programs in the community that will allow for some additional funds, more than just regular public assistance, which sometimes is limited. And we know that a lot of people might be facing large arrears because they haven't paid in many months. And typical public assistance programs don't go back very many months. And so we're looking at that and how we can cover as much back rent as possible when an individual becomes eligible for public assistance. Thank you.
Thanks, Denise. Mark, you've introduced yourself already, but want to tell us a little bit more about what your organization is doing to prepare?
Yes, absolutely. Thanks. Again, Mark Moyo from the Legal Aid Society, and the Legal Aid Society is partnering with some of the other legal service organizations. People might know Law New York, Legal Assistance of Western New York, and Volunteer Legal Services Project, VLSP, as they're sometimes known. We all share a building, but we're working together in our various housing units to try to provide assistance or legal counsel to everyone who is facing eviction in the coming year. So we've, 2 nights ago, the City Council approved some money for that. And so I've been trying to gear up my unit for that work and hiring some folks and meeting on a daily basis with not only my colleagues, but like I said before, people in the court system, people who do work like Jamie, and other community organizations to try and pull the system together so that hopefully that justice is done and it works for everyone.
Fantastic. All right, we'll go to question number 2. So before COVID moratorium, can you tell us how the new 2019 eviction laws may have changed your operations or processes back in your organization? I'll let anybody take this one to start.
I can start.
Great.
So as a HUD certified housing educator, we have a team of HUD certified housing counselors who man a hotline. I hope maybe some of you have taken advantage of this previously, but we had to hold the phone, literally, put calls on hold and do some studying. There was a lot of changes. We had a lot of documents and resources for the community and an operating rental property guide and a book, and as well as a class. And we had to restructure all of it, rewrite the book literally. So our team took some time to regroup, retrain, make sure that the documents that we share, we don't have attorneys on our staff, we're truly educators. So we had to take things off of our website, any free templates that we make available to the community, any information we are sharing on proper notice, and the general things that are true of all situations had to come down and be restructured. So we worked with our partners at the City of Rochester, legal service providers to make sure that we were updating the things that we make available to you through our website and through our hotline, and make sure our team was on the same page so we could accurately give that information. And to this day, we're still being affected by these changes because a lot of the questions that are coming into our staff, we still are telling folks to reach out to a legal professional, an attorney for further navigation. We're here as a first step, give some general guidance, but we are making sure that folks have resources to go to for those more complicated situations.
Fantastic. Anybody else want to chime in?
I guess I'll go. It's obviously been much harder for landlords in the new era of the HSTPA, from everything from the inception of the application process through the eviction process. It's relearning what you used to know and trying to understand and navigate through that. And we were just getting to the point, I think, before COVID, of just getting used to some of the ways things were being handled. I will connect the two and say that I think, but for some of the changes to the HSTPA, maybe the impact wouldn't be so bad in COVID, because we were seeing on average pre-HSTPA, as Mark indicated, timeframes that in some capacity, you were at 1 or 2 months before you would get into court and you would get a resolution. We were seeing in some locales, especially in town and village courts that were non-regular parts, upwards of like 90 days in some instances before people would get a court date. And for those landlords who, November, December, January, didn't want to go ahead and evict anybody because most landlords do not do it at the end of the year. Now they're finding themselves almost 9 and 10 months in without rent being paid because of COVID. So I think the length of time, getting used to it, recognizing, and our group did many surveys to figure out what it was about the HSTPA that was the most hard to swallow. And we were really seeing landlords have to alter their resident selection criteria because many of them were concerned without the double security deposit and things of that nature. So I think it's gotten harder on both sides, harder to be a landlord, but harder to also be a tenant and get access to properties. We were seeing like a sliding scale of tenants who used to be able to get building A being, only able to get building B, and then somebody being left out and not being able to get housing at all under these new laws. So unintended consequences, they're great in some respects.
Great.
My answer to this question is the same as those that went before me, that just learning the new laws, making sure that I'm giving my clients the right information, making what I hope to be valid arguments to the judge if I have to do that. And then in some cases, developing issues that might need to be litigated further on certain facts. So that's what we've been working toward to try and make sure that everybody's understanding the law in the same way. Laws, let's say.
Great. Denise, any major changes within DHS and how it's affecting your clients?
Not necessarily. The emergency assistance that can be provided through public assistance actually doesn't require legal eviction. And so an individual just have to provide verification that they were past due to be eligible for back rent. And so if people came to us early enough, we could assist if they were eligible. But to Mary's point, we leaned on them a lot for guidance that we could give individuals who came to us asking about legal evictions, but that is not always required for public assistance help. So it did not, we could still assist people if they came to us. We don't know if maybe people didn't come because they were not facing a legal eviction. The same thing was even during COVID now. We don't know if people don't come to us because they're not facing an eviction, but they absolutely could because it is not a requirement to receive public assistance right now.
Great, thank you. All right, with that, we'll move on to question 3. This is more directed towards the lawyers as well as Mary from Housing Council. The 2019 laws were aimed at providing tenants more protections and promoting housing stability, especially for vulnerable populations. Do you believe that these new laws are having that desired impact? Jamie, you want to start?
Sure. I think in part, and I think in part they're hurting them. One of the surveys we conducted right in the beginning was, again, access to the units. And we saw a distinct carved out class of seniors, first-time renters, foreign nationals. Because credit score is now more heavily relied upon because they have taken away some of the abilities to do other screening mechanisms. Landlords have raised those as a reaction in some instances. And so again, when you take just a senior as an example and they're retired and they're not working, maybe their credit isn't as strong as it used to be, but they're sitting on a whole bunch of money in the bank. What we're seeing is that landlords are not as quick to rent to those specific types of tenants, where before this, they were able to take a double security deposit and they were able to say, okay, you might not meet my full credit score, but because of the double security deposit, we're comfortable making that concession to allow you to live there. So I think the unintended consequences, again, are that some groups are finding it harder to get access. And, the heartstring there for our coalition has been trying to argue that children are getting less access to school districts that they once before could have had access to. So it's unfortunate there. The other thing I will point out is that we've seen an increase in crime in some areas around the inability to screen certain tenants for prior eviction history. And our group, just to get it out in the open here, is we have proposed amendments to the HSTPA that we were kind of shopping around Albany before this happened. And one of the things that we wanted to make sure is that there was sort of a distinguishing factor of what type of eviction. Obviously, we would never want to deal with non-payment. People have issues. We recognize that, and we never want to create a barrier to them to get housing. But for violent issues that have happened in the past, or breaches of lease that you can track, a tenant may have 4 or 5 different leases in the past 4 or 5 years, and every time there's a similar issue. The neighborhoods have cried out to our organization to say there's a lack of safety in some elements. So the due diligence that a landlord is able to do has been somewhat put in a compromising position in some instances. So I think those are the two that I've seen. But I think there are positives also. There were definitely things that could have been revised to protect tenants. And I think that the law in part does accomplish many of that.
Thank you, Jamie. Mark, have you chime in now?
Sure. I mean, my answer in general is yes. I will not sit here and say that the laws are perfect in any way, but they weren't before either. So the protections that were instituted regarding, let's say, looking at people's past eviction histories. In my practice, as a person who represents tenants, I'm not sure if I said that out loud very, very many times, but been representing tenants for almost 11 years in city court, was harming people's ability to find new places to go. I think that credit scores probably maybe track things like that in general. Somebody might have a lower credit score if they're not able to pay their rent over a period of time and have been evicted. But the eviction lists, let's call them that had been created or were being passed around, in a lot of cases hurt people who weren't those people because they were completely unvetted. They bore they had no responsibility outside of that, whereas credit reports do. There's federal laws regarding credit reports about how to fix them. And don't let me be heard to say that those are perfect either. But at least there is a system involved there to try and get rid of inconsistencies or things that are not correct. So I think that its goal, let's call it that, was to allow people more time to make good on their contractual arrangements if we're talking about non-payment cases. And I think that has been effective. It allows people more time to find a safe landing or to pay back the rent that they might otherwise owe. In the past, I would have cases where, I'll just say it out loud, where we would have what we call snap hearings, which is we appear in court, we can't negotiate a settlement, and the judge would hold a factual hearing right then and there, which I found to be completely unjust in a lot of cases. And the people would be issued warrants of eviction if they didn't have every single dollar that the judge found right there. So this gives people more time to come up with rent. If they do have a valid factual defense, then that can be heard with some development and some assistance and in getting those facts out there, whether it's in documents or in other form. So when I'm defending people, I think that it makes the system a lot more just. I can definitely understand that on the outside or when people are trying to re-rent, that it's caused a lot of problems. So I will not deny that. But that's where I'm coming from.
Great. Mary, how about your perspective?
Yeah, I think we have a unique perspective at the Housing Council. We are talking to folks on all parts of the housing spectrum. And so how this has affected the acute relationships, short-term relationships between landlords and tenants with the problem they're dealing with now versus the downriver effects of how folks who were tenants under one set of laws and looking for housing, maybe getting more stable or facing issues, folks may be wanting to transition into home ownership because of some of the effects of these laws, or some of the folks who were, I've heard from a lot of landlords who said, look, I can't manage with this set of laws. So I think there's a lot of long-term problems, not just the short-term adjustment to these laws. My feeling overall for statewide policies and laws, it's a broad stroke. It's a big program with lots of unintended effects, positive and negative. I want to highlight something Mark brought up earlier with, I think part of the intention of this is that we wanted to put it more in line, the protections for tenants to be more in line with the timeline that homeowners have, to address some of the inequity in housing that's inherent to tenants versus homeowners, and try to balance the scales in some way. So it addresses a lot of timing issues. We do see that there are unintended consequences of this new timing for both tenants and landlords. And the issue that I think that goes maybe unrecognized or doesn't get the most attention when we're talking about the new laws is ultimately there's an unhealthy and unstable relationship in a lot of tenant-landlord relationships. And the only way to address many of the issues that tenants and landlords are facing is through eviction court. So really, a lot of times when people are calling us on the hotline and saying, I'm behind on my rent, I'm facing eviction, but then they have 20 other things that they're dealing with. And by extending the timeline of eviction, maybe some of those other issues that they're dealing with can get rectified, housing quality, repairs, income instability, a short-term issue that they're having. And I think part of the hope was that by extending these timelines, it would give more time to the network of resources that are available to tenants and landlords to address some of those issues, so that we don't have to use eviction as the way to problem solve for other housing issues that our community is facing. So income is a huge problem when we're talking about eviction. The ability for human service providers to get the assistance that eligible families are eligible for to them in the amount of time that they have to work with. Many of our services are not designed to work in short-term emergency service timeframes. And it's not perfect. We're going to keep tweaking it. No first draft of anything works great the first time. And I think by making such broad changes, so many stakeholders are following the leadership of folks like Jamie and Mark and others to say, hey, now we're paying attention. We got used to the last set of laws. We knew how to work it. We're having to revamp our entire business model, and our communities are having to adjust to the new needs people have under them. And it's bringing a lot of voices to the table that had been silent for quite a long time. So if we're not happy with it, we're going to get engaged and we're going to improve it, but we're moving in the right direction.
Great, thank you, panelists. Very good perspectives all around. All right, we have one more prepared question, and hopefully we'll have a little time for submitted questions. So since the COVID moratorium began, many landlords have gone months without rent. What resources would you recommend for a landlord to navigate both the financial and legal issues they're facing with this resource crunch?
So I'll lead, I guess, for our group, we've been encouraging landlords to obviously first start by reaching out to their tenants and trying to open lines of communication to figure out, is it a COVID problem? And if it is, what can be done? We encouraged everybody to work with the security deposits when asked, and educated them on the law on that to try and help get some cash flow to landlords, because that was, something to help. The CARES Act funds, that's something we have actually had guests on the roundtable from the continuum of care, and tried to encourage people to reach out to organizations like Catholic Charities and figure out if there's any help. And I know, Mark and I are sitting on variety of subgroups that are trying to get this organized at the court level. But all of this, before the courts had gotten involved, we've been trying to educate and at least give avenues. For landlords, it's been really tough. The PPP exempted landlords as passive business owners, so they weren't able to get that loan. They recognize that they do have obligations to pay, things like the taxes, the water, sewer, mortgages, their payroll, their contractors. So it's much more than just, we hear things like, oh, you just can't pay your mortgage, or that. It's so much bigger than that. And the implications of not being able to pay the taxes will hurt everybody, from school teachers to fire departments to the police. So I am hopeful that when the courts open and we get communication to sort of misdirect some of the things that we've been hearing not necessarily up here, but on a statewide level, there are a lot of advocates out there that were championing going on rent strikes and holding parties to do so in COVID. And we tried to temper that for our group and to really be a resource again, and to mount those frustrations with a resource they can listen to, but also change it into positive energy to, so again, try and break out of this model of being greedy landlords and racist landlords. That's not what we need on either side of things. We need to work together. And so it's really fostering that communication. So for landlords, I guess my best advice is hold on. The court, as it's going to roll out, I've been saying every day since I've been part of it, I do feel like this is the best setup to be in a position to address all of the concerns in a vacuum and hopefully get some help. And Mark, maybe you can lend some more to that, but I think it's coming.
Yeah,
Thanks. Mark, yeah, go ahead.
Sure, I can try and answer some of that. There's a lot of, let's call it federal CARES money that came down to the municipalities, and that they're doing their best to, and Denise can maybe talk in details, to help people who are in a difficult situation. And I'm speaking about the tenants, but then obviously subsequently the landlords, and hopefully that can try and make people whole, or whatever we consider whole to be at this point. So whether it's coming from the city of Rochester and running through Catholic Family Center, whether there are other community organizations that are out there, DHS, there are things coming down the line that are not exactly 100% in force quite yet. So if I'm a landlord or if I'm communicating with the community, I just want you to keep your ears open for all that stuff that's going to be coming out soon. And I don't mean to play hide the ball, but if people aren't ready to take phone calls, I'm not going to start giving out phone numbers. So, just keep a lookout for press releases and politicians talking about things that are coming down the line. So again, sorry to play hide the ball, but I'm not about to hand out information that's not ready to go.
Great, and we will have a little bit more on some of those details in later on in the presentation. Denise, though, do you want to address what resources you'd recommend for landlords?
Yeah, so I would recommend for landlords, I think what everyone else was saying too about communication. When clients call us and indicate that they're having an issue with the landlord, that's the first thing we say, is that they need to communicate to the landlord. If we're paying a portion of the rent and they're not able to pay their portion because they lost their income or have changed in income, it's really about communication. So encouraging them to let us know when they have a change, that we can adjust their cases as needed. If they have, if their case is closed and we stop the rent, for them to be communicating with the landlord to let the landlord know that they're trying to rectify the case closing so that the closing can be canceled. What we see right now is new clients coming in, maybe people who haven't been on public assistance before, and you're filling out landlord statements for them. I'd make sure that on the landlord statement you indicate the past due rent, because we're trying to look at those cases as we open them and address any back rent that we can right at the case opening. Again, without having a legal eviction. I saw in the chat that Mary had a question about that a legal eviction is not required for public assistance. That changed many, many years ago. We did used to require a legal eviction, and that some clarification of the regulations for us changed many years ago, and we don't need that. All we need is verification that the rent is past due. And so you can indicate that right on the landlord statement. So when you're sending someone in, or you're working with one of your tenants that is applying, make sure that's indicated on the landlord statement. And I know we're going to talk a little later, like Mark said, we're not ready really there'll be, some press releases in the next couple of weeks, but the county and the city both making some CARES Act funding available above and beyond regular public assistance that will have some different requirements, some different income requirements. So you might have tenants that were never eligible for public benefits before that might be eligible for some of this other funding, because the income limits will be higher. And we hope to be able to get that money directly to landlords through applications at CBOs and other entities, because we know that we won't be able to handle the crush ourselves at public assistance. You know, we have just the 691 St. Paul Street office that's taking individuals in with social distancing. We're never going to have as many people as we had in that waiting room in the future. And so we'll be limited, but we'll be working with community partners to accept applications on our behalf and get this funding out, again, directly to landlords, and get notices out to you that will let you know when individuals are eligible and when you could expect to receive funding from either regular public assistance or some of the other special funding programs that are going to get announced in the next few weeks.
Great. Finally, Mary, real quick, you want to address top resources for landlords?
Quickly, yeah, we have a bunch of resources at the Housing Council. We have a Landlord Ambassador program. You can get one-on-one work with a professional to talk about your current practices, connect you to resources that are available in the community now. There will be lots of press releases and programs specifically for tenants, which will benefit landlords indirectly. But at the Housing Council, we have some information about resources that are available now, have been available, and will continue to be available directly to landlords. To advertise those, we're going to be doing a lunch and learn on September 2nd from 12 to 1 to talk about some of the things that are happening at the city. DRHP, which is another local housing nonprofit, and what we're doing at Pastone through our home rehab and energy services program. In addition to back rent, we know a lot of folks have had deferred maintenance and other questions and concerns about being able to afford the maintenance of their properties during this time. If you're not getting rent, you're probably not really able to invest in your properties. So yeah, we're going to be holding tight until courts reopen and funds are available to tenants. So in this meantime, I think it would be a great opportunity for you to reach out to the Housing Council, our Landlord Ambassador program, and go over your business practices, screenings if you think you're going to be looking for new tenants in the short term. Many of the applicants for your upcoming apartments are going to be people who were evicted previously, because it's just going to be a musical chairs of people who fell behind. So how are we going to be screening tenants coming into us to resolve some of these issues? So if you're interested in that one-on-one service, please reach out to us. And then if you want to start with some of our classes, those are all available virtually. You can also call us on our hotline from 9 to 1 with just some basic quick questions. We try to get you either a quick answer or a referral to the right place of what you're looking for. So call us 546-3700 from 9 to 1 Monday through Friday. And if the calls increase, we'll increase those hours as well.
Great, thanks, Mary. And we will have that number in the PowerPoint slides later, and will be distributed to the attendees. All right, so we have time for one question, and then we'll have to address the other questions we've gotten so far at the end, where we have almost an hour for question and answer time. I'm going to stop screen sharing just so we can see each other and pull up the chat so we can look at some questions. All right. How do I deliver a 14-day notice to a tenant? And can it be delivered tomorrow, or do I have to wait until October 1st?
Jamie, there you go.
All right, so I guess this is an interpretation because it's hard, right? So this is unprecedented because we have some cases already filed in that had been done in July that are just kind of waiting. What I have told clients is to continuously watch to make sure that the notice to quit has not been cured, because if it's cured and its rent's been paid, a new one is necessary. However, with the late notice, I would continuously make sure that notice goes every single month to bring it forward, to make sure that you're still having that form of communication to say rent is still due and it has not been paid. I don't know, and I don't know if Mark, you know what the judge will do when we get into court if a 14-day hasn't been given to the tenant the very preceding month before we end up actually getting in court. It's not a bad idea. It's probably a safeguard that I would encourage you to do. And again, I think there's some legal arguments on both sides to whether or not a new one is necessary if the old one is still not paid. So That's my point of view on that.
Right.
And
It was
again,
a
we're
little-
not giving legal advice.
It was a little unkind of me to throw that to Jamie because
That's
it is
okay.
it's a hard question. And I'll tell you the way to serve it is RPAPL 735. That's pretty clear about how to serve that paperwork. But in terms of whether you can give it now, I don't know the answer to that. I know there are different interpretations out there, and Jamie just outlined them. Some people think that you can, other people think because there's not an action that you can file now and it needs to be updated in the future, that right now it might not be good. I do not know what a judge would do. In the past, judges have done different things with those. And again, because we were still learning those new laws and people were taking different positions, that's one of the things that I was kind of referencing earlier, saying that things haven't gone through the appellate process yet. So we don't have a clear answer for you. It depends on your level of risk that you want to take, I would say.
And in general, you're recommending to engage a lawyer for all of our landlords.
Yeah, I wouldn't do any of this on my own. Even if you are in a jurisdiction that allows you to go into court on your own, despite the fact you're an LLC, and I know those judges exist out there, I would not navigate this without counsel. Besides the fact, if there's counsel on both sides, this should go faster and be more thorough in evaluating all the different elements that are going to go into the claims.
Yeah, and just to double up on that, when you're thinking about the timelines that I outlined before, if you have to refile and do this all again, if you mess up your 14-day notice and that gets kicked out, that's 14 days and then 17 more days and then a hearing and then a 14-day warrant that you have to redo all of that to get yourself back into court. Probably worth the money to go see an attorney. Now, I mean, maybe you want to do it one time or consult with them, but in some form, I think it's a good idea to speak to an attorney about these issues.
Great, thanks guys. So we're going to save the rest of the questions we've got on this topic to the big Q&A time at the end. Now I'm going to restart screen sharing and kick it over to our city highlights with Commissioner Gary Kirkmeyer and Kurt Martin, who's our Director of Buildings and Housing.
Thanks, Henry. Tremendous amount of information so far. There's going to be more to come. We're going to now be able to talk about some of the resources that we're trying to allocate to deal with some of the challenges that we've been hearing and we know are a priority for you. If you can get that, there you go. So, you know, the city has received about $10.2 million overall in CARES Act funding. That's through 3 different mechanisms or pipelines, CDBG, ESG, and HAPWA. And we'll talk about those a little more in the next slide. But one of the things we wanted to do, you know, some of it was for business assistance and a lot of it we wanted to dedicate to housing objectives because we know the impact that's going to be substantial to both landlords and tenants in this environment. So our housing objective, if you will, was, you know, targeted to avoid massive displacement of residents, avoid increased homelessness, and try to recoup as much of the lost rents for landlords as we can. And we're trying to do that through a targeted approach via 4 different programs or efforts. One, and the primary one, is to provide adequate direct assistance in the form of rent arrears. And so, you know, adequate is the key word there. And, you know, Elijah talked about one of the surveys we did with landlords through our Harvard partners, but there's been a couple other surveys as well. So we took all the data from that and try to forecast, you know, best case, worst case scenario and try to allocate resources accordingly. We wanted to provide funding to vacant unit rehab so that in the event that we have residents, especially our low income residents that were in need of housing, that landlords who were suffering financially and may not have had the resources to rehab that vacant unit would be availed, at least in a reimbursable format, the opportunity to do so. We want to work with our community housing partner organizations in HUD to streamline the rental assistance process. And we're going to talk a little bit more about that, but we know that that's going to be a big logjam. You know, there's some more information that's going to come out as others, Denise and others have referenced in the very near future, some things we won't be able to talk about today. But that's a primary focus of all of our efforts, is to make sure that these processes can be facilitated in an efficient manner, because we know there's a lot of people to serve. And we're also partnering with the Justice for All effort, because we want to be able to provide legal representation for all tenants in the eviction process. And that's been a goal for this community for quite some time. COVID actually makes that in some ways a reality. And we think that will benefit all, because having, as Jamie and Mark just referenced, having lawyers on both sides of that table, we believe and we support the theory that will make the process much more efficient and effective for all parties. Next slide, Henry. So here's the direct rent assistance allocation. So again, ESG, Emergency Solutions Grants, CDBG, and a round 2 of ESG that we just went through City Council, as Mark alluded to earlier. So right now, we have dedicated that 1.1 and the 900,000 to Catholic Family Center, and that's the agency that has always assisted us with rental assistance, topics and issues. And so we didn't want to reinvent the wheel. We wanted to be able to support their ability to ramp up resources so they can serve, again, this is what we envision to be a logjam of demand. And then the council item the other night, the 2.1 was part of a 2.8 second round of funding. And we fully intend to dedicate as much of that as we can to this rent assistance effort, but we left this 2.1 flexible enough to say, if it proves in fact not to be necessary there, we can use it for other homelessness eviction prevention mechanisms. But we fully intend to dedicate as much of that as needed to rent assistance. We did have to, and we continue to engage HUD in these processes. These are federal dollars. They come through HUD, and with that comes a lot of regulatory hoops and obstacles, if you will, sometimes. So we were able to get some waivers. One we weren't able to get is the assistance to tenants cannot begin until the 14-day notice is served. So, we'll talk about that in a later slide, but we were able to get a lot of other, considerations met with waiver requests to make the process as streamlined as it can be. And then again, this is a subject, this last bullet here, that we can't talk a lot about today, but you'll hear about this in the near future here from a community, partnership effort to streamline the intake process. And again, much more to come on that soon. Next slide. So in addition to the direct rent assistance, here's some other resources that went towards eviction prevention / homelessness prevention. So you can see collectively, we've allocated almost 6.5 million of the 10.2 million to housing and primarily to eviction / homelessness prevention. Next. So, now it's, a lot of questions were, how can I assist? How can I direct tenants? How can I engage tenants? How can I help them navigate these systems and processes? Well, in one respect, a lot of people like to say, just call so-and-so. And what we would like to say is, let's make sure that we educate people in the process. And, to this extent, I'll go through these bullets, but we'll send out a one-page summary of what that intake process is, as captured and depicted by our partners, our community partners, and our housing unit. But simply put, here's a few things that tenants should know that they're going to have to consider to determine their eligibility. So, have you lost income related to COVID-19 pandemic? I mean, remember, all of this funding is to address COVID impacted issues. So this funding, there's other funding that may be able to support needs outside of COVID, but this funding that I'm talking about is all COVID related and can only be used to help people impacted by COVID. You have to be in emergency danger of eviction, homeless, or loss of housing or utility shut off. That's where that 14-day notice comes in. That's immediate danger of eviction. So that's kind of the trigger in most scenarios. And then, the income qualifications are depicted in this chart. Again, I think we're posting this online so you can access this information at your leisure, but it's also going to be captured on that one-page summary that we'll send out to everybody that registered today. Next. So beyond that, assessment of eligibility, this is kind of the direction as of today. And so, once a tenant determines that they met that eligibility, a call to Catholic Family Center is appropriate, and they can start that intake and application and if necessary, referral process that may involve DHS. Applicants will receive a checklist of required documents they have to submit. At the appointment, the eligibility will be confirmed and documentation collected. And if necessary, a follow-up appointment will be scheduled. Paperwork will be finalized. That's where you come into play. You'll sign the agreement acknowledging assistance paid, and the payment will be sent directly to the landlord. Nonprofit partners will follow up with tenants because we not only want to help the current situation, but we also want, and our community partners are in business, to make sure that the tenant is set forth on a path of stabilized housing. Next. And so what can landlords do? We've already talked a little bit about this, but keep an open dialogue, encourage tenants to pay what they can, know your rights, know the tenant's rights, have the tenant call Catholic Family Center to discuss options and apply. As Mary already has alluded to, the Housing Council is always there and available to answer questions and help people through process, both on the landlord and tenant side. And then we have financial empowerment centers that, again, we want to help to build up tenants, help them with finances, and help them structure themselves to avoid displacement, to avoid delinquencies in the future. And then, make sure that you respond to requests from nonprofits. Resolution usually results in positive outcomes for all stakeholders. Again, this is a primarily set up to serve tenants, but it serves tenants and landlords in the process. Next. We talked a little bit about the Right to Counsel project. Mark talked about it a little bit. There's going to be much more coming out about it. I can't say much more than that today. But if you want more information on that or assistance tenants, there's a number and an email address that tenants can reach out to. Again, this PowerPoint will be available. So shifting over to the Landlord Grant, hopefully you all received it. I know we sent the grant program information out to everybody that registered for last year's summit, and I believe we sent it earlier on to people that were that had prior registered for this event. We will send it again to everybody that joined us today, in addition to that one-page summary. Next, Henry. So the grant, in simple terms, it's up to $2,000 for reimbursement for the cost of repairs or maintenance to a vacant unit. And I will tell you that this came about from two different perspectives or angles. One was early on in COVID, there was some thought or theory that landlords who are already going to be suffering the impact of tenants not being able to pay were not going to be able to avail vacant units, whether they didn't have the resources to fix them or whether they didn't have an interest in occupying them with tenants that may be in a threat of not being able to pay the rent. And so it was combined with our, our interest in, again, supporting landlords and supporting tenants through landlords, that we developed this grant program. So the eligibilities are, you have to have a vacant unit, obviously. You have to be current on taxes, both city and county. You can't be in foreclosure. You got to be in good standing with code enforcement. And that doesn't mean you can't have violations. It just means you have to do the things that we expect, which is communicate, have a work plan, progress at least as on deals with health and safety issues. And then you can't be included on the federal excluded parties and entity list. That's a HUD requirement. Next. So it's kind of a 2 or 3 step process. So you apply before you do any work, because we're going to have to see before and after, obviously. So you do an application, you'll get a notice to proceed, and then you just have to, at the end of the process, demonstrate that the work was done and that you either paid cost for materials and or a contractor. You'll have to have a 12-month lease with the tenant, and you're going to have to demonstrate that that tenant is at or below 60% AMI, and those figures are depicted in that chart. which again, you'll have access to this both in the program details that we send you and the PowerPoint that'll be posted online. Next. So now I'm going to turn it over to Kurt Martin. Kurt is our Director of Buildings and Zoning. He's going to talk about, some of you may be already familiar with our temporary inspection policy. We had to develop something that reintroduces how we do inspections, given the dynamics of the pandemic, both for your safety, for the public safety, and for our safety and the safety of our employees. So Kurt's going to go through what we perfected via engagement with our with our landlord organization leaders and our tenant advocate leaders, and then we'll talk more about it thereafter. Kurt.
Good afternoon, everybody. Thank you for joining us in such a strange circumstance. I'm Kurt Martin. I'm the Director of Buildings and Zoning again, for those that don't know me. And as Gary said, we had to come up with a temporary inspection policy in response to the pandemic. So we've made adjustments to the inspection protocol to protect both staff and the public while continuing to ensure that everybody has a safe and habitable housing. This policy breaks down the following activities: for new construction inspections, complaint inspections, both exterior and interior, the certificate of occupancy inspections, which we consider to be an incentive-based interior inspection relief for 1 and 2 family structures and multiple dwellings. We're also going to talk about referrals and rehab grants and home buyer inspections. So next. So a common thread of the policy for each part of this is going to be safety protocols, and they're applicable to all types of inspections. They're pretty much common sense, but I would like to go through them just to make sure that everybody's aware of what they are. Upon confirmation of the appointments, the inspector will ask the contact if they are feeling sick, have a fever, or are being either treated for COVID-19 or under quarantine. Pretty typical, even if you go to the doctor. I know I went to the doctor this week and they asked me the same questions. They want to know what you're going to be confronted with. Both the inspector and the customers must be wearing masks or facial coverings at all times. If anybody doesn't have a mask or a facial covering, we are going to have our inspectors armed with extras that we can hand out. There's what we call a no-touch policy. The occupant or owner shall be the ones to touch the items. That keeps our staff safe, like windows, doors, faucets, smoke, carbon monoxide detectors. And the inspector will simply verify what is being asked. Where a dust wipe test is being required, it shall be performed separately from the initial inspection rather, unless the subject unit is vacant and the time permits the ability for the inspector to do the test. During any necessary interior inspection, there should be no more than 1 adult accompanying the inspector. An exception can be made for 1 adult resident and 1 owner agent rep. We're trying to limit the amount of people that we're being exposed to, so be mindful of that. Any previously cited interior violations may be abated via video evidence of compliance upon inspector's verification. We actually came up with a virtual inspection guideline. It's on our website, and we can get that sent out to everybody that's attending today. Next. So new construction inspections, pretty much standard protocol. We're continuing to do construction inspections. If you look around, there's a lot of development happening in the city. There's a lot going on, and we continue to do those inspections. The appointments will be efficiently scheduled, so the inspector is not on site for any more time than needed. We'd love to keep them less than 1 hour. And where reasonable, compliance may be achieved by video evidence again, and we're going to talk about that a little bit later. Next. Complaint inspections. Most all of you are familiar with our complaint inspection policy. Exterior complaints can be handled in the same manner as they always have been. And any necessary interaction with the caller, the complainant will be accomplished via the phone or conferencing. The inspector generally doesn't need to be interacting with anybody for exterior inspections. Interior complaint inspections. Upon receipt of the interior complaint, the city staff will follow the steps outlined in the complaint policy as we always have, because that's established. And once the complaint policy has been followed and the necessary inspection is to be scheduled, the following criteria must be met in order for the inspection to be performed. The support staff person will ask the caller if they are feeling sick, same thing, right? So are you feeling sick? Have you been exposed to anybody? Are you under quarantine? Because we don't want to schedule an appointment and impact the safety of our inspector. Or if a manager or owner is going to be on that inspection as well. Upon confirmation of the appointment, the inspector will ask the same series of questions. So tenants are going to be asked these questions pretty regularly, and it's going to become our protocol until we get out of this. Next. And again, for the interior, appointments will only be scheduled for health and safety related items and concerns, because we don't want to be dragged into an interior inspection if it's not health and safety related. Those are our priorities, and we're going to stick to that more stringently while we're in the COVID-19 pandemic. The inspection will be efficiently performed, just like I said, with a focus on health and safety. Next. So here's where it gets a little bit more complex. We're kicking off getting the C of O process moving again. As many of you know, we had to stop doing C of O inspections, but we've got to start easing back into it. And this is where we spend some time on trying to figure out the best way to achieve the goals of our policies and getting back into the swing of things. So our C of O program inspection presents the most complicated challenge, as you can imagine, for you as well. This is due to the extensive review of the entire structure and the premises. And it becomes, because of the applicable lead testing, it's complex. The protocol is designed to be reasonable and to maximize our ability to ensure safe and habitable housing while ensuring the safety of both staff and public without compromising the integrity of our lead ordinance. It's important that we keep that integrity. Next. So for 1 and 2 family dwellings, we've come up with a way to give, as I said, an incentive-based relief. And how that works is an exterior inspection shall be performed if code compliant and no previous Monroe County lead hazard history. So we'll take a look at our support staff's looking at history before even scheduling appointments. If there's no history of Monroe County lead hazards, and there's no exterior violations, we'll ask that an affidavit be submitted by both the tenant and the owner. And what we'll do is, if all of those are met, we will issue a 3-year C of O. And so that's in lieu of an interior inspection requirement. Where there's a Monroe County Department of Health lead history, the interior must be inspected, and it would default back to the full inspection process in a 6-year C of O once achieved. Next. Multi-dwellings. A full inspection of the exterior and interior common areas will be performed. We will do a random sampling of 40%, no less than 40% of the total units will be inspected, and we'd round up that number if need be. Selected randomly by the inspector upon arrival. So these aren't going to be chosen by the management companies or the landlords. The inspector will pick and will equally distribute those units for each level of the structure. The overall total number of units that will be inspected is based on that 40% units, not containing any visible interior deteriorated paint, fire safety, or other hazardous violations. Next. If any of those violations are identified and the units inspected, then all the units will require an inspection. So basically it's common sense, right? If it's in good shape, the ones we hit in that 40%, if it's good, we don't have to go any further. But if we start seeing violations, a full inspection of all units is going to be done. For those units not inspected, the owner agent shall supply an affidavit attesting to the condition of those units. So an affidavit will have to be filled out for each unit not inspected. Next. And we've got a standard affidavit form, which can be used both for any part of this temporary inspection policy and or the virtual inspection that we will allow in lieu of a reinspection and in new construction. Next. Referrals. The majority of our referrals come from the fire department. As you can imagine, when they get called, they usually send us items that are code violation in nature. So we review those, and generally we will react to most of them prior to the COVID-19 pandemic. But now that we're under restrictions, we are just going to react to those that involve hazardous conditions. And where NBD staff have been provided with direct contact for the occupant as part of the referral. And that means good numbers, good names, who we're going to be dealing with. And we've talked to the fire department about getting that information to us. We get many referrals that don't have all the proper information, and it's hard for us to follow up. So we're just asking that we have really good contact information for either tenants or management companies, landlords. And any of the other referrals from outside agencies must encourage the residents to come through the complaint process. So, minor issues that don't rise to the hazardous condition level, we just ask that they follow normal process through complaints. Next. Our rehab grants and homebuyer inspection programs, they continue. We are ramped up and we've started to do inspections again for the rehab grants and homebuyer. Same protocol applies here. In the course of performing an interior inspection, when we have to verify what the grant is for, we will, that no touch policy again. We don't want our staff to be opening windows, to turning on water, flushing toilets, turning on lights, any of those things. It's common sense. We're going to ask the person that we're with, whether that be a landlord or a tenant, to do so. That will keep us from being impacted. And then the inspection will be efficiently performed with a focus on grant subject area. Again, keeping the time that we're impacted on an interior and exposure to a limited amount of time. Next. That's it.
Great, thank you, Kurt. And we're actually going to do a live poll right now. I know this is a very dry subject, important subject, but dry subject. So we wanted to get a sense of if you were previously aware that we put out this temporary inspection policy. Great, and now we're sharing results. It looks like about 65% were not previously aware of this temporary policy. So we're really glad we're sharing it with you now, and hopefully we will continue to promote and educate the community about this policy. Kurt, you want to have any final words on where people can find more information about this?
Yeah, we are sending out our renewal C of O letters, and we are putting this policy in the same envelope as the renewals. We're going to send it to everybody that is attending today. And I believe if we don't have it on our website, we will post it on our website. The other thing I want to add too is about the guidelines for virtual inspection. We will send that out. We are taking, in lieu of a re-inspection, we are taking virtual inspections. I was hoping we'd have an example of that today, but we didn't have a good enough quality video to be able to do so. But if anybody's interested in that, they can reach to me and read the guidelines that we put forth that are going to be sent out. And if there's any questions, again, contact me or anybody in code enforcement.
Great, thanks, Kurt. We're all going to do one more, a little more silly poll, break up the subjects here. make sure, see if people are really paying attention. Don't worry, this is anonymous. All right, let's call it. All right, so thanks for indulging us. You know, just a good way to break up a very densely packed day of information. What's the strangest thing you've done while attending a meeting on Zoom? Our number one response was other. My lips are sealed. People are very close to the vest, 44%. Thanks for playing. All right, moving on. We're gonna head back into updates and back with Commissioner Gary Kirkmeyer.
Thanks, Henry. You can go to the next slide. So if we were live at the convention center, we'd probably get up and stretch at this point. Hopefully you're able to do that wherever you're situated. So I think most of you know what City Rise is, but I'll just give it a really quick recap of what it is. The Attorney General's office has facilitated 3 different funding streams, primarily to deal with vacant and abandoned properties. The first one was the land bank legislation and funding associated with that. The second one was the zombie grant, which we are recipients of both round 1 and round 2 of the zombie grant. And then the City Rise grant, which is in round 3 now. Round 1 is the vehicle by which it brought us building blocks. Hopefully you are all familiar with building blocks. It's a data platform that allows you to pretty much manage your business if you wanted to. It's got all of our data in it, not only code enforcement, but crime, you know, water, and all kinds of other data, assessment data that's in there, merged all in one place, so you can merge it all together. The round 2 City Rise was about equitable code enforcement and engaging our hard to reach population of residents. And so we did so. And then in round 2, we formed, with the help of the ASH team at Harvard, formed a grant request for round 3 that was targeted to serve, you know, and enhance the equitable nature of code enforcement. You know, if you can't connect inequitable code enforcement, you know, there's a lot of times where code enforcement, if not properly deployed, can have unintended consequences to, you know, the innocent victim, if you will. So we want to make sure our policies, programs, and the way that we facilitate process doesn't have those unintended consequences. So phase 3, our grant, these are the topics and the programs that we were pursuing. Land management, anybody that attended last year's event, you know about land management. I certainly hope you all are tuned into land management subject. If you're not, you're going to hear more and more about it. In a nutshell, the city still operates in an old legacy mainframe system, and they're all siloed system. We have a building information system, a real estate system, a refuse system, a water system, so on and so forth. Well, land management is basically an enterprise solution for front-end users. So, you know, NBD is all public facing. So all of our programs and processes are all public facing and front line. So, go back. So we want to make sure that we have the most efficient way to serve people, and you have the most effective way to navigate through the various processes that you have to involve yourself in. That's one thing. We are intending on developing an emergency abatement, hazard abatement program, more of a policy than anything. And that has to do with the equitable nature of code enforcement and these unintended consequences that I spoke briefly about. If you think about some of the situations you may have seen in the media a couple of years ago where, you know, certainly not anybody on the line now, because these types of individuals don't take the time proactively to master their business model, if you will. But we had a landlord that was from afar that did not really have a good business model. It certainly wasn't a successful business model. And that led to a lot of residents being impacted immediately with things like no heat. So we wanted to make sure that we have the mechanisms to deal with that in a more direct manner than issuing fines and taking people to court, which are really slow processes. So that's what this emergency hazard abatement program is going to get to. We want to develop a property manager licensing program. And I know some of you might be of the mindset with, oh no, another regulatory function. But I do know, and I do know some of those individuals are on the line right now, that we have been asked for over 20 years to do such a thing by you, by your peers. And why? Because it levels the playing field, if you will. If you think about it in terms of property A, which is managed by manager B, doesn't do the right thing, but you are doing the right thing, and them doing the wrong thing has a negative detrimental impact on you because the property is right next door to you. That's kind of what we're getting at. We believe that this vehicle, more than any other thing we're doing, will institute automated accountability that will level the playing field and make sure that we can focus our limited resources on those, what I would say is a smaller percent of individuals who aren't doing the right thing. And again, certainly nobody that's online today. We are partnering with the Housing Authority, basically expanding our financial assistance centers, financial empowerment centers to serve, our support, reducing evictions with RHA, which is our biggest landlord in the city. And then through our registered refugee resettlement services, we've partnered with them in phase 2 of City Rise. We want to keep partnering with them to serve our refugee population. We really had a positive experience engaging them. They're a hard to reach group, many different languages, many different ethnic groups. And we want to stay engaged with that population because, they do have a very large presence in our city. And we want them to be part of the overall effort that we're putting forth. Next. So again, land management, I talked a bit about this. If you think about it in terms of the manually intensive way that we engage you now, and we send you a paper document, you send it in or walk it in. You can email it in now, but then you got to go and pay for it or send in a check. What we've seen to date from the vendors, we did scripted demos with several vendors. We're now down to one vendor that we're trying to negotiate a contract with. We hope to go to council with that contract in October and begin implementation in January. But what we've seen from the vendors' demonstrations, this is going to remarkably change your business life and your relationship and interactions with the city, and in particular buildings and zoning, because that's where we're starting implementation. Anything that you can think of in terms of managing your housing infrastructure, in terms of where you have outstanding issues, where your C of Os are expiring, how you're getting notified about issues, this is all going to dramatically change in the near future here. It's going to be a painful process to implement, but we're going to get it done successfully. And in the very near future here, it's going to help serve the way that you manage your operations. And these are just some of the benefits that we can see automatically. You're going to have electronic workflow, not just submit an electronic document, but workflow processes. So if you submit a building permit, for example, not only do you get to submit it, but if you submit it properly and it's accepted, now you can start to schedule the inspections. If it's a C of O, same thing. You submit it, you can start to schedule inspections. You yourself online. You can get electronic email notifications when you're behind in scheduling inspections or when the case is of a certain date. And we can send email blasts as many people as we have registered for the property. So it doesn't have to be limited to the owner or one agent. You're going to be able to see the workflow. When you see a case and you click on it, you're going to be able to see where it is in our process. So you know firsthand, where we are and where we're going. Right now, we depend on the inspector's limited time and ability to contact and actually touch base with you. That's, that is a very difficult dynamic because it balances both their limited time and your limited time. And, connecting the parties is often the biggest hurdle we have here. And then, of course, setting up a dashboard. We certainly hope and fully intend to be able to have you be able to set up a dashboard again so you can manage your assets in the city of Rochester in a much more proactive and productive manner. Next. So I talked about this a little bit. I think I probably covered most of it. The one thing that I'll add to this is we are soliciting today participants who want to join a committee, if you will, of landlords/agents that will discuss this further. We do have a draft that law is just checking for legality right now. It's certainly not a perfected document. It's not a final draft. We've engaged some landlords and tenant advocate groups to date, but we want to form a committee to finalize this program before we put it out. So that basically you all know under what circumstances we're going to dispatch a contractor to remedy a situation that the landlord/agent has failed to do so. Next. And then the property manager license program, same thing. One of the reasons why I mentioned the fact that we've had some of the people in the crowd today come up to us as long ago as 20 years and asked us, why don't we license property managers? One of the reasons why we haven't been able to is technology. We don't have the capacity to manually, score, gauge, judge, try to get an assessment of how somebody's doing. It is a manually intensive process. If you got somebody that owns 10, 20 properties and you have different inspectors managing all those cases and trying to holistically see how somebody is actually doing in their business, that's a challenging endeavor right now. But using things like our data tool building blocks and certainly into the future with our land management project, we're going to have the convenient capability to construct a scoring mechanism, an automated scoring mechanism that's in line with what you agree is fair and reasonable. Because at the end of the day, you all know, if you've been in business here in the city of Rochester, you all know that we are all about reasonableness, fairness, and transparency. And once we institute something that has expectations, it's going to be supported by the people that volunteer to participate, and we will act accordingly. And I suspect that it's going to serve all of you very well, because I don't suspect that there's anybody online that would find themselves having a poor score and being the focus of our code enforcement attention. We're going to model it kind of, if you think of property manager, we're not talking in the terms of state licensed broker. We're talking about more in the form of our building owner registry. Who's the responsible party to keep up with property maintenance for the property? So that's kind of where we're going with the definition. And again, we're gonna do a survey. I don't know if Henry's doing it right now or shortly, but please volunteer. We're gonna have more volunteers than we can handle. We don't want to have 50 people, if you will, but we'll do some kind of computer randomized selection and get a reasonable group put together to continue these conversations. So if you're interested, please sign up.
Yep, there's a poll just popped up. We're going to use this poll to solicit people who are interested in participating. We'll have your email through Zoom and we'll follow up. We'll leave this one open a little bit longer just to make sure everybody wants to respond.
And let me just go back to and really quickly just summarize, because I know we've been saying we're going to send a lot of things. So, we've talked about the grant. We're going to send that out again. We talked about the process of getting rent assistance. We're going to send that out again. Kurt talked about the inspection policy. We're going to send that out again. The virtual policy, the affidavit, all of that will be packaged in one email to everybody that registered today.
That's right. And it'll be posted on the website for this event, cityofrochester.gov/Landlord Summit.
We got more time, Henry? Are you waiting still, or?
We are keeping the poll open. We'll just give it another 10 seconds. Last call.
All right. Let me quickly add one other subject that wasn't captured on the PowerPoint. Many of you may be familiar with the fact that we used to post code compliant rental properties and the C of O information online, both in the property information system and building blocks. We had to pull that C of O information out because there was a problem with the data. We're working through that problem right now and fully intend to add it back to building blocks and the property information system. But there were some problems we were having systematically with some quirks with mixed use structures and it accurately depicting what the expiration date was. And we want to make sure that that's correct before we start pushing it out to the public. So look for that soon. We're also going to push out the building permit history on properties in building blocks, and we're going to continue to add to building blocks. So again, if you're not familiar with building blocks, it is a tremendously useful data tool that you can use to not only assess current conditions with current assets, but where you may want to invest in additional assets.
That's right. And folks can find that on our website as well if you search building blocks on cityofrochester.gov. All right, we've closed the poll. We did get 100 people interested in participating. Thank you for your interest. We'll be following up via email with you to invite you to a follow-up session with this committee. Great. We have 3 minutes to spare. Anything final you want to share, Gary, before we head into question and answer? I know you have closing remarks as well at the end. All right. Seeing none, we will move into our 55 minutes we've allocated for question and answer. So we're going to do this in order of topic. And like I said before, Jill, my colleague, has been watching the Q&A and organizing questions by topic and avoiding duplicated questions. So the panelists who are on, as well as any of the other folks who are panelists in Zoom can chime in and to respond if necessary. So first, we're going to spend 15 minutes talking about the new tenant laws and evictions and any follow-up questions from the panel earlier. I'm going to stop screen sharing and so we can see each other. All right, and panelists, please turn on your video and sound if you're responding. So going back to the top, a couple easy questions to respond to. Do these policies, does the eviction law apply to the whole state? Yes. This eviction law and the moratorium apply to the entire state from what was presented by Mark. Question, do we know when the courts are going to reopen? I'll take a panelist response, please.
So it gets a little complicated, so I'm going to do my best. But any case that was filed before March 17th that was either heard by a judge or was filed and never heard by a judge, or in a third category where a warrant was issued but never fully executed, those cases, and I'll just tell you, it's my understanding, each of those cases is going to be conferenced in front of a judge, and I'm in city court or in the towns, you're going to get a letter if you fall into that category. You or your attorney and your attorney are going to get a letter giving you a court date. It's going to be, I think, at either 9:30 in the morning or 2 p.m. on a certain date for a conference to be held. I don't believe that the judge is going to have the ability to issue a warrant on that date because, as we discussed earlier, all warrants are either state or can't be issued until after October 1st. And since these are going to start taking place on September 1st, the judge isn't really going to have the ability to use any sort of a warrant condition. That's at least my understanding right now. But I just want to be clear that some things in there are fluid, and because they haven't happened yet, I only have the information that I have.
Right. It seems like the one very clear point is nobody can actually be physically evicted until October 1st, no matter the scenario.
That's my understanding, yes.
Great. All right, I'm going to move down through. So a general question I think we touched on, but haven't been able to collect rent and I can't evict my tenant. What are my rights? How can I collect the money? Can I collect the money?
So I think I can answer from this. It's communication. Obviously, we still encourage you to communicate. Hopefully when the courts open, as I mentioned previously, it will be an opportunity to make sure that everybody's on the same page about what the laws are. There have been, as I mentioned, so many executive orders, first of all, and then you top administrative orders. A lot of the tenants are just not aware as to what the procedure and the law is right now in New York. And so eviction moratorium versus cancel rent is very confusing to some of our tenants, and they don't understand the differences. And I am hopeful that the number of people that are facing eviction for non-payment actually have the money there. They just don't know if they have to pay it in some instances to make those numbers less. And then, it's for the landlord, it's trying to figure out what is the capacity to maintain their tenancy and to set payment arrangements. Making sure that, we hashtag in our coalition compassion for tenants. I think it's unique to have a landlord group with that hashtag, recognizing nobody asked for COVID to occur, and asking for compassion back to our landlords, because anything that a tenant can do, we should be encouraging them to do, and wanting to work with tenant associations to get to that point where they do set the laws right and they do say rent's still owed in the state of New York, and encouraging anybody who can pay to recognize that may help maintain a landlord through the end of the year and not have to declare bankruptcy or close shop right now. I think it's very important to acknowledge those paying tenants are going to be sacrificed if landlords can't make it to the end of all their obligations.
And to add on just a little bit to what Jamie said, on top of the moratoriums that have come from executive order, a new law passed in, I think, the end of June or the very beginning of July, the New York State Safe Harbor Act, which threw in some more complications and more things for tenants who might not be lawyers to worry about or to think about, and for landlords as well. So we haven't said the Safe Harbor Act yet, but it basically states that any person who's been financially impacted by COVID, which is only defined by a couple of things, but says that those aren't the only things, cannot be evicted for not paying their rent. You can get a money judgment, but those months of rent are essentially what we would call non-possessory. So you can't get a warrant of eviction for non-payment of rent after March 7th through a date uncertain in the future. So that's if, and Jamie can add on to this if I have it in any way wrong, but if somebody's been financially impacted by COVID, then this law would come into effect. It's an affirmative defense, so somebody would have to state that on the record or prove it if necessary, but that's part of the discussion going on now.
Yep. I agree with Mark, what he said, and that Tenant Protection Act for sure.
Great. I guess quick question on small claims court. Is that an avenue people should be trying, or should they be sticking with the eviction, official process?
It depends on your circumstances. If somebody doesn't have possession of the property anymore, I saw one of those questions in the Q&A. Landlord tenant court is mainly for possession. And that's what a lot of judges will tell you in certain cases. If someone has moved out, you're really not going to get the relief you're looking for in landlord tenant court. So that'd be what we call either a plenary proceeding to get a judgment in city court or Supreme Court, or you can go to small claims court depending on where the property is, how much money you're looking for. Those are all contingent factors in going to small claims court. I think that answers the question. Sorry.
Great. Thank you. So in general, we are encouraging communication with the tenants, try to put together a plan, get them back on track. What types of what would you suggest in terms of formalizing a payment plan, you know, if somebody is trying to get back on track?
So you definitely want to put it in writing. You know, whether or not that's waiting till court is involved in that process. And we've been advocating for some form of ADR so that there is conversation and more people available to help the tenant. We do think it's important from our coalition standpoint to have the tenants represented so that we don't have a payment made and then undone by an order to show cause when they talk to an attorney. I think it is very important that at this stage, tenants are being counseled and know the law and have it straight before they make any decisions on what they're going to bind themselves to. I think landlords, if they can give longevity of time to make those payment arrangements, great. Most have, I will tell you, almost every one of the landlords, and we represent about 2,500 across the state, almost everybody has done where they could do a payment arrangement to minimize the evictions that will be filed. But I think that, you know, when we look at it, detailing, you know, core terms, when the payment's due, how much is going to be paid towards rent that becomes due, how much is going to be paid towards arrears, whether or not those payments are going to be due on the same day. That may be very hard for a tenant to be able to pay everything on the first of the month. So recognizing some considerations for maybe split payments, maybe one on the 1st, one on the 15th, or one on the 1st, one on the 30th or 25th. Be flexible. Again, everybody needs to work together. I keep referring to this as a Jenga game. And when I talk to people saying we built the housing, now we've got to maintain the stability. And every time we pull out a piece, we're weakening it. So, you know, whether it's tenants just willfully not paying or a landlord locking a tenant out, that's going to destabilize the whole structure. So communication, key, working together, key, and recognizing sympathy and empathy on both sides, because we're very sympathetic in the public light to the tenants, and nothing really to date has been a major support to landlords. And I think we stand to be the city that could do that and show it's really a problem. The statistical data is showing, you know, rent shortfalls in excess of way over 30 to 40%. That's just really scary, because that equals homelessness, people that, you know, won't have housing if these individual landlords can't make it. So encouraging the process to maintain itself is my thing.
It's great. Are there existing templates, maybe a question for Mary, templates for these types of workout agreements, you know, getting somebody back on track? Is that something the Housing Council has?
Yeah, we love templates. We love things that can help people move this process along. I think Jamie and Mark are bringing up great points. We don't actually know when you're going to get in front of a judge. So the best thing you can do is maintain this relationship with your tenant. And the odds are, even if someday they are evicted, the person you're going to be filling that spot with is somebody who was delinquent previously. So we need to document that you're doing your best effort to have a great relationship. The Housing Council's website, we try to make a lot of things available for free download. We've created a Corona response page. We're adding things to that, templates we like from other organizations, templates we find from other nonprofit legal services providers. We don't really have the capacity to review something that you're going to create over our hotline service, but if you do want to make an appointment with our landlord ambassador, they would talk to you about how to structure some kind of template to document what both parties are going to be doing to remediate the situation as best they can until they can have some formal agreement. So that is definitely support that we can provide, and stay updated on our website with the new things that we're putting on there to hopefully share some best practices that we're finding.
Great. Question for everybody. If a landlord has hit an impasse with a tenant, the communication is just not healthy or whatever, are there mediation type services before you have to go to court that you can engage to help with that communication?
We're working on that from the court perspective. I'm sitting on the ADR subcommittee, so that is something that's being formulated. I'm sure more details will be rolled out about that process shortly.
And I would just add that the court is a lot more likely to take ADR resolutions if both parties are represented, especially if it's done by video or written stipulation. If both parties are represented, then they're going to be likely to take that outside of a court appearance, personally in court. So it could save people a lot of time and energy to make that happen and get an agreement on the record. And we're hoping that the funding that we're talking about from DHS, community organizations, and elsewhere can come in and make those agreements happen.
Lastly, if we can't get a financial agreement worked out in the meantime, and you just want to get back to positive communication, the relationships develop, we've always recommended that folks approach Center for Dispute Settlement if both parties are willing to meet with a licensed or an accredited mediator. Maybe you just need to get that communication open again to work towards something positive in the future. So we always recommend the Center for Dispute Settlement here in Rochester.
Great. All right, I've got another technical question. If a landlord wants to terminate a lease sometime during this period, can they do that given the 2019 laws and the COVID moratorium? And how does that work?
So we need to kind of bifurcate that for a second. New York State laws were different than CARES Act and the federal side of things. So I'll speak to the New York side of things first, I guess, and then somebody else if they want to take the federal. But under New York State, it was a law change. So section RPL 232B changed in the HSTPA as it applies to landlords. Now landlords need to follow RPL section 226C, which is a brand new section under the HSTPA, which requires a landlord to look at the totality of the time that the tenant has resided at that property, not just the most recent lease. It's actually in the amendment to the HSTPA, it specified the culmination of the time period. If they have been in the possession for under a year, then it's a 30-day notice still. If it's the year to just before the 2-year mark, 1 day before the 2, it's a 60-day notice. And anything where there's a lease over 2 years or equal to a 2-year time period, that's a 90-day notice. That would need to be complied with if your lease expired in COVID. That is something that would still, I'm assuming the judges are still going to be looking for that. I know when we terminate that, we make sure we attach all of the documents to my petition. I'm probably a little bit unique in that, but I do give the judge as part of the petition all the supporting notifications that are required with the affidavits of service. I don't know if anybody else wants to take CARES Act but if you want me to just keep going, the CARES Act specifically as it related to non-payment did prohibit any notices from going out until July 24th. Thereafter, it was required to give a notice of termination. You could start that on July 25th if you wanted to terminate the tenancy. There was much conversation about whether 14-day notices counted as a notice to terminate. I think all the attorneys ended up in Rochester folding into doing a 30-day notice. So if you had a federal backed mortgage or you had a tenant that was subject to any one of the VAWA protections that were enumerated, then you would have had to serve that notice before you would be able to terminate. Recognizing that if you are terminating a tenancy, that you might not just be subject to the 30, you need to look at your lease and make sure and consult counsel whether or not the 30, 60, 90 also would apply to your scenario under federal law.
Right. And I guess follow-up question is, so if somebody terminated the lease and the tenant refused to vacate, what would be the process to actually evict? Would that still be on hold per the moratorium?
Yes. So the most recent Judge Mark's order that we just got does clarify that holdovers that were or will be commenced after March 17th are on hold. That's the first time we got the word holdover specified in any of the documents to my knowledge. So those are stayed still also. I can tell you there is a need, and there is conversation taking place in Albany about violations that rise to criminal levels. We are very concerned that in the governor's executive order 202.8, dating back to the original order, there were exceptions for code violations and things like that for tenants in COVID to commence an action if necessary. We are hoping that at some point we can get a reciprocal carve out if there's a gravity of circumstance, like a criminal offense or some kind of major objectionable conduct that occurs on the property, because we have seen, unfortunately, an uptick of that in COVID, and landlords have no resource there, and it's, you know, unfortunately spilling over so that other tenants are affected. Right now, there is no distinguishing those types of cases. So that is a concern of landlords.
So really, unfortunately, can't do anything about a criminal squatter type situation.
All on hold. You know, I myself, I have filed some. I'm not sure what the judges are going to do with that. There is a portion of the law under section RPL 713 where no landlord-tenant relationship exists, which would cover your squatters, your licensees. I do have some like that, some pre-COVID like that, some post-COVID like that. So, you know, the governor did give some protections to people who would otherwise be deemed squatters in COVID, so that if they were there for a period of 30 days or more, they weren't going to be considered squatters. So it's really important for you guys to look and go to an attorney to make sure you have the most up-to-date and best information based on your case facts, because these are landlord-tenant law. I mean, Mark, you could probably agree with me. Landlord-tenant law used to be like somewhat easy, right? Now it is fields of lots of different bombs and things waiting to get you. And, you know, I tell my clients all the time, don't navigate that yourself. There is so much change. It is so fluid and so hard to put it all together to make sure you're understanding. Talk to an attorney.
Absolutely right. Yes.
No,
Great. Anything else on that point? Otherwise, I got another one.
No, Jamie did a good job separating out lease violations or criminal activity from squatters. That's important.
Gotcha. So this is a sticky one, but basically, how do you approach a tenant who is working? They seem to have the money. They clearly seem to be, they just seem to know that they don't need to pay and the system is working in their favor. How do you approach that situation of tenant really taking advantage of the moment and the system?
Well, I guess I would say, I mean, at some point things are going to come to a head or come to a point, and they're going to have to make a decision whether they have kept this money. Maybe there are things that are unseen in terms of, or on the opposite side, maybe there are things that are unseen in terms of COVID hardship. You know, I've been able to keep my job. I'm very lucky, but I have had a lot of things happening with family members and childcare. And so if someone was in a worse position than me, and plenty of people are, so those are things that might be unseen. Maybe someone is keeping their job and making $10 or $12 an hour, but other things happened where somebody fell sick and couldn't watch their kids anymore and they had to pay for something. So those, whether that is in the law as a COVID hardship, I do not know, but those are facts that we are probably going to have to litigate on fact by fact, case by case basis. So I just want to point that part out.
I agree too. And I think to add to Mark, this is the case impression situation where you're going to see people who would never be evicted in the past. There are some professionals, lawyers, you know, CPAs who just lost their jobs in this, whose jobs were eliminated because the business couldn't pay everybody. So it is not just people who are in the lower income bracket. And I think that's important to note, that this is different. And there are people, to Mark's point, who, you know, two families who have kids, or two family households, or two parent households, thank you, who one has stopped having to work, and we're going to see it. I mean, my school district's only going for 2 hours a day. That requires somebody to stay home with my kids. Those are tough decisions to be making and could have an economic impact on the way that the family is able to pay the rent. And so I think we're going to see a lot of first impressions on evictions and sad stories.
Just to add to that, it is true. Most of the people who are not paying rent are unable to pay rent. Renters want to pay so they can stabilize their housing. Some people may be flat out taking advantage of what they understand the conditions to be. And I hear that. I hear it probably more often than I think it's actually happening, because as Mark and Jamie are saying, people are very private about their hardships. So it's a mixed bag. But if this is your concern, that you're not being paid and you have no indication that a true hardship is happening, you can invite your tenants through a statement that says, just an account of where we stand at this point. These are the months that have gone unpaid. These are the records I have for partial payments or whatever's happened over the course of time you're concerned about. Explain to them that you're engaging in resources to be able to keep your business afloat and that you are still delivering the services promised to them. And if they need additional resources to create a plan, and because they intend on staying, you can include the Housing Council's hotline. They can call and get information about the truth around what's happening when you're not paying rent, the truth that they will be issued a judgment even if they are not evicted from the property. So if they do have a true COVID-related hardship, and if whenever they get seen by a judge, they could be issued a judgment and what impact that would have on future housing choices, their ability to get a car, their ability to buy a house in the future, all of those things. A third party could be a good resource to share the true facts. So it's not heard through a lens of my big bad landlord's coming after me for money. Or if you feel just uncomfortable having that conversation, point people to other resources, so the financial empowerment centers, so they can understand the repercussions of their choices. Or maybe it's not a choice, maybe they actually can't pay, but what their options are going to be down the road, because we're not going to be in this particular disaster forever. There'll be fallout for a long time, but we're going to have to navigate our way through and get people on the right road to get out as soon as possible.
And I just want to add something, Henry. So people might have been receiving pandemic unemployment, and we would all look at those situations and say, you should have paid, you had enough money to pay. And where we stand now, where individuals are not receiving that, when we look at a case that they apply for public benefits, we only look at the month of application. So a person could be eligible for some back rent payments, even though they had the income during that time. Now they may have to pay it back to us, but they could be eligible for it. So people shouldn't think that they can't apply because they had what would seem like the income to pay during the months that they owe, because we know it's over now and we would consider the income in this current month, and they would have to, of course, be under the income limit now. But most likely people are if they have reduced hours or if they have just the New York State unemployment. So people should be encouraged to apply for public assistance and have the back rent considered, even if they had income during those months that would have covered it.
Gotcha. That's helpful. Very complex situation, and we appreciate that. So we are out of time for this section. Any other questions on this topic, we will address in writing and send back out to all the attendees and post on the website. So look for that hopefully by end of next week on the website. We're going to switch gears to talk about some of the new landlord and tenant programming and funding resources. All right. So first question is, does the government have a program to pay landlords past due rent?
So I guess, our response to that would be in the information that I covered, right? It's through direct rent assistance to the tenant, that payment will go to the landlord. Of course, following that process and all the eligibility standards.
Yeah, and at DHS ours is the same. So it goes to the landlord, but the application has to be made by the tenant or the client, and it's based on the client or tenant's income. But when we make the payment, we would make it directly to the landlord or to the mortgage holder.
Great. So yeah, again, in that process, I think communication between the landlord and tenant will be important, because in that process, the landlord will need to be engaged to give their, their address, bank information, et cetera. So encourage your tenants to look into these programs. Another question: will there be free legal services for landlords?
In my time at the Legal Aid Society, I've helped plenty of landlords at various levels. So let's say sometimes just answering questions, sometimes helping them fill out paperwork where they represent themselves at court, and then at other times actually representing people in court on various sets of facts. The funding that we're getting is not inclusive of landlord representation. So that's a lot of times what our confines are in terms of our contract with either the city of Rochester, Monroe County, the state government. So under these circumstances, we're not going to be opening it up to landlords to represent them for free, especially since we're kind of sort of saying that we're going to be representing all tenants. It would create an immediate conflict.
I will see, to step in on that landlord side of things, my roundtable is completely open. There is no membership requirement. So any landlord who is necessarily looking for some free pieces of advice, I give it daily, and happy to help support or at least guide to assist in that. Just, shoot me an email and I'd be glad to see what we can help with.
Same here. I mean, we have a registration fee for some of our classes. We're going to be holding specific topics related to this process as it goes forward. There's no eligibility based on your income or previous income to be included in any of our programming. Same with that landlord ambassador. The landlord ambassador is not an attorney, but she will be able to make referrals, and there are resources around BLSP and Monroe County Bar Association Legal Referral Service that we can make. Can't promise free services, but we can provide affordable guidance to navigate the process.
Great. All right. Next question. Can a tenant apply for assistance if they get other housing assistance like Section 8 or other benefit funding?
Yeah, they'll follow the same process. Again, the funding that we referenced today primarily was COVID related. So assuming they were impacted by COVID, that funding would apply. There's also other funding in the community that's not tied to COVID, but they would facilitate or reach out through the same processes.
For the most part, tenant rent amount should have been adjusted if the household had a change in income. If they were on Section 8, a subsidy that's based on their household income should have been adjusted, but at DHS, yes, we pay even if a person has subsidy.
Great. Next question. Is there a way to find out if the tenant has applied to for the rent support?
I guess I won't speak for Catholic families, but, we want, again, we're going to reinforce engaging in the process. So, you should be aware of that through your conversations, continued conversations with the tenant. It's a problem you jointly own with them or you are a part of. And so, to the extent that you can be on the same page with respect to that process, you're ultimately going to be involved with that process and know they're in the process because you'll have to play a role in it. But I think communication is key in knowing, where you are in that process.
Yeah, it's my understanding that for the ESG funded program, as well as for us, we're going to be asking the tenant for a ledger from you about the background that's owed, and then calling you to confirm that information is accurate. And so while you may not be able to call us at DHS and say, can you tell me if Joe Smith applied? Because we wouldn't be able to do that unless Joe Smith explicitly gave permission for us to release that. But if they do apply, you're going to get a call from us that says, hey, Joe Smith is your tenant at such and such a place. you know, he's applying, is this information accurate? And then let you know that they have applied and they're pending with us and a determination is pending.
Right. And follow-up question is, will the landlords receive the check directly?
Yes.
That's the same for your programming, Denise, inside DHS? Yes. So
Even if ongoing rent isn't on voucher to a landlord, anytime we pay back rent, it always goes on voucher to the landlord. We won't do that directly to a client.
great. Next question. Many tenants have been denied assistance. Are the guidelines supportive of all tenant situations?
So again, there's a variety of funding that's, you know, directed towards direct rent assistance. Not all of it is CDBG or ESG or even HUD related. So CDBG for the most part serves residents at or below 80% AMI. ESG is at or below 50% AMI. And then Catholic Family Center also gets resources from outside of those funding streams that can serve the people above 80%.
Yeah, and most denials are usually not related to income. They are of someone being excess income. What's usually the reason for denial in all programs, the ESG funded programs, the CDBG, our programs, United Way funded programs, is that the tenant doesn't have the ability to pay the rent ongoing. And that is a requirement for almost all programs. So when a person has no income at all and they owe 3 months of back rent, no program is going to issue them 3 months of back rent when they can't pay the ongoing rent. And so then the person is usually referred to DHS to apply for ongoing assistance. And one, that's where you see a delay because we cannot make a determination on back rent until the person gets through the eligibility process and we make a decision that yes, okay, their case will be open and now they will have ongoing rent assistance, the ability to pay ongoing. So then we can address the back rent as well as pay the ongoing for rent. But if a person doesn't apply timely for DHS or doesn't get through the eligibility process, gets denied, has to reapply, or just takes longer than normal to get all their documentation in, then that prevents them from getting the back rent assistance because all of these programs have this requirement that you have the ability to pay ongoing. And if the rent is so high that even on public assistance, they can't afford it ongoing, and they don't have a family member or friend that's really to write an attestation that they'll cover the difference, then they wouldn't be eligible either. So those usually denials revolve around that inability to pay the rent ongoing, and that's where people get hung up because really there's no solution to that, and the back rent won't be paid because future rent can't be paid.
And what resources would we want to send people to if they truly were denied from some of these programs?
I mean, these are programs that we have. They should consult with. Housing Council might have other information. 211 might be able to direct them to other resources. The programs that we depicted today are the primary programs that we support to help support residents.
Right, and I would say some of the community work that's being done is to try to help people through the process at DHS. So we didn't talk about it in depth today, but the programs that you'll hear about that Gary alluded to about a community-wide solution really work for people who don't have ongoing income to help them get through the DHS process. Because one of the biggest things at DHS is our application is 21 pages, and so sometimes people can't even get through that to start the process. And so we will have community agencies that will be helping people even with something that simple to get them started, because at least once we receive the application, we can go from there and work with them. So those are things that are going to be coming and really some kind of community support, because those people are just going to have to keep coming back to DHS to try to get through the process. And the process is much different in COVID. We don't do face-to-face interviews. All the employment requirements are waived. And so people have been getting their cases open much faster because the eligibility process is much abbreviated, but some people still need help. And so these community agencies will be helping us with that process So hopefully people can get the ongoing rent, the ongoing income to pay rent established, and then that way the back rent can be addressed.
Great. Thank you, Denise. All right, we are out of time for this topic. Next, we're moving into code enforcement questions. Again, any additional questions on benefits and new programs, we'll address in writing following the session. All right, code enforcement questions. So I was in mid-CFO inspection in March. This is a landlord speaking. How and when is my final inspection?
So I'll comment, and then Kurt can chime in as well. So as Kurt alluded to when we talked about the current inspection protocols, if we did a full inspection, certainly we can abate interior violations using the video evidence as per the policy that you'll get a copy of if you don't now have a copy of it. You know, it has to be clearly depicted. Think of it in terms of if an inspector was there that long ago, they need to be comfortable and familiar with what you're depicting on the video that you shoot. So you have to show the house you're walking up to. You have to talk him or her through the inspection. You have to talk your way into the particular apartment that's in question. You have to talk your way into the particular area of the unit that was subject to the code violation, because it's only in the inspector feeling 100% comfortable that he or she can validate that as abatement, that we can use the virtual policy. Now, that aside, you can certainly call and schedule a reinspection. We're open for business. We're just going to follow that protocol that Kurt went through before. Exterior violations, we can see that without even any involvement to the extent that you can see it from the right of way. So yes, you can get through the process as soon as you're ready for it.
Yeah, the only thing I have to add is, you know, we would invite people to call us and get on a schedule for an appointment as fast as you can, as you know, when you're ready, because we would like to get more of these properties that are out there that started the process to completion, so we can move on to the next batch, because we are 4.5 months behind with our C of O processing. So anybody that is out there that is interested in getting inspections, you can do it virtually as long as you follow the guidelines, or call and get an inspection set up as soon as possible.
Great. Next one. What COVID-19 requirements need to be met by the landlord to prepare a property for new tenants?
So I don't know if Jamie's familiar with any of the state applicable policies, and I'll certainly defer to her if she is.
Go ahead, answer.
Okay.
I'll chime in if necessary.
Yeah, so you know, we're not regulating that, if you will. You know, I think common sense rules the day here. You should be preparing that unit and cleaning that unit to the same extent you would do your own environment, to the same extent that we do our work environment. You know, so practicing clean, proper mechanisms to clean properly, and do your best to prepare it in a manner that, you know, serves both the tenant and yourself.
I will add to that just to say, maintenance policies when you're entering a unit, showings, if you're doing showings, I would highly encourage, number one, reducing it to writing so that you have a policy and a procedure for everybody to follow, but also to make sure you're asking those key questions, whether somebody has been in proximity to somebody who has symptoms or has tested positive or is subject to quarantine rules, whether or not you've left the country, whether or not now you are part of a travel requirement for quarantine because you've traveled outside one of New York State to one of the affected areas based on the governor's executive order. Making sure that you ask those questions ahead of time before you do anything so that you don't impact either your worker or somebody who's going to be receiving the services to the unit or showings or things like that. So just be very careful of that and make sure they are reduced to writing so that you have a record and can contract trace if necessary.
Gotcha. But no city COVID-19 in terms of actually preparing a unit beyond the inspection process, there's no,
We're not doing additional inspections, COVID related, no.
Yeah, there was, it's been very hard to get any guidance out of the state for property specifically. I will tell you, my coalition leader and I tried very hard to get the New York State Empire Development to give us like specifics as to things revolving around code and maintenance and things. And we just never even heard back on certain points we asked for.
And I'll tell you, the ones we're familiar with is like the gyms that want to open now that they can open. The health department will have to perform inspections inside of 2 weeks of them opening, but we have not received any guidance in terms of our responsibility in residential settings.
Correct. I second that.
all right. Well, next question. What is the plan of action to address slumlords who have multiple properties, multiple violations, and no C of O? This is not necessarily related.
Yeah, so that's, thank you for that question. We don't really use the term slumlord, but I'll say somebody with a bad business model. You know, everything that we talked about today in the evolution of the forward-thinking operation that we're talking about is purposefully designed to allow us the opportunity to focus our limited resources and capacity and authority for where it's most worthy of our time. What, you know, there's the challenge with running a rental inspection program, because I can tell you no one in the country does it like us, nobody. Everybody claims they do, but when you dig down deep enough, we're going in 14,000 units a year. Be hard pressed outside of New York City to find somebody doing that. So when you're doing that, it kind of bogs down the structure, and code enforcement in terms of issuing tickets, that's not an issue. We issue 4,800 a year. Now, COVID impact is we want to step back, right? And say, we know landlords are impacted. We know tenants are impacted. We know their ability to comply is impacted. So to the extent that we're talking about blight and non-hazard, we've kind of pulled the reins back a little bit during this period of time. As Kurt mentioned, we pulled back the C of O renewal process. So, you know, we're slowly getting back up to speed. But all of these programs that we're talking about and all this technology we're talking about using is purposefully to let the light shine where it needs to shine most, which, you know, it's undebatable where the worst properties are and who the worst property owners / managers are. It will stick out like a sore thumb when we can navigate through deprioritizing those that are doing the right thing. So all these incentive-based protocols that we just deployed, you know, you want to take advantage of that. We want you to carry smoke alarms with you during the C of O. We want you to carry carbon monoxides with you on the C of O. If that's the only issue and you mitigate it, we're only going 40% of the units in a multiple. Prepare for your inspection, because you are, for the most part, everybody on this call is doing the right thing. You're not the problem. And you can help us focus on the problem by getting us through your properties in an expedited manner.
All right, that's all we had on code enforcement. If any other follow-up questions, please submit them and we'll get back to you in writing. Next topic is our other section. Anything else related to stuff we presented or other questions? So first question we have is really from a property manager perspective related to the licensing program. Sometimes the lack of repairs is not due to the property manager, but it's due to the owner not wanting to make those repairs and invest in their property. How will we kind of parse through that with the licensing program?
That is an excellent question. So I think whoever recorded it, that is exactly what we are trying to eliminate, right? Is to right the playing field here. We have to eliminate that problem. How do you eliminate that problem? The same way we do with private refuse haulers, right? So in the city of Rochester, if you have something other than a 1, 2, or 3 family, you can have private refuse service. So if you're paying for private refuse service and you stop paying your bill and that refuse piles up, we tell the company, get your equipment out of here and we'll go after the owner for not having refuse service. The same rule applies here. If you are a local dedicated rep for property managers, legit property managers, and you find yourself in a partnership relationship with somebody who's not dedicated to maintaining their property, our advice to you is going to be sever that relationship, and we'll go after that person for not having a reputable local property manager, because if they're from afar, they're going to need somebody local to represent them. So this will have, over time, this will have built-in accountability that not only pushes that type of investor out of our area, but also make sure that the people that do have good intentions locally, that want to really represent people right, will not have that type of client, because you're going to sever your relationship with them, because it's going to be detrimental to you if you don't. And it's going to be detrimental to them when you do.
Great. Next question. Does the city have a procedure to help a landlord who cannot pay their taxes or water due to COVID, besides asking the tenant to apply for assistance?
City has tax agreement process. Code enforcement does have a role in that process. It starts with tax collections, obviously. And they have a structured, protocols in terms of how much down payment you have to have and how far out you can spread that payment. I think it's 10% in 5 years. But code enforcement does have authority to sign off on those applications. And we do look holistically at all of the assets of that applicant. So if the applicant is the type of person that wants to protect or preserve 3 of their 5 assets, and the other 2 are fire damaged pits that are detrimental to the neighborhoods, they're not going to get a tax agreement, not short of remedying that situation. So it's a collective effort on the part of finance and neighborhood and business development, but it's a very easy process if you're not in that depicted scenario.
Also, it's that through our Landlord Ambassador program, we can help with the communication and advocate for plans to be put in place, especially with mortgage companies. So taxes as well will help you with the communication with the city, but mortgage especially is something we're very good at. So you can reach out to us and work with somebody to help navigate that and advocate for you.
Great. Yeah. So in addition to contacting Housing Council, Mary's organization, to apply for a tax agreement, you can go right on the city website and search tax agreement. And there's a web page on how to start that process. All right. Another question we got related to licensing is basically, can we license property managers and or contractors?
Legally, we can, yeah. We can't supersede state law that licenses brokers, which we don't intend to do. We're really going to license people or certify people, one way or another, that are responsible as the point of contact for property maintenance issues. So yes, we can go down that path, and that's the path that we're going to discuss going forward. Contractors, we do license electricians, plumbers, stationary engineers, people in the elevator business. We have not contemplated going beyond that at this point with general contractors. We have the authority to do that. It's more about, it's hard to create new processes now if there's not some form of funding associated with that to support it. Government since 2007 has been shrinking pretty dramatically. For those of you that don't know, we've lost like 33% of inspection staff since 2007, and you wouldn't know that when looking at the structure, but that's because of the things that we've done to combine inspection staff throughout the city and cross-train people. But we are in a fiscal crisis. We're in the same challenged environment that landlords and other business operators are, and it remains to be seen how desperate this situation is going to be for local governments.
Absolutely. One quick one back up into eviction and property law. Can a landlord raise the rent during the pandemic and the moratorium?
Subject to 226C, I would say. So landlords are under an obligation, if they're going to increase rent 5% or more, to notify the tenant they're going to do so. That has to follow the 30, 60, 90-day rule. There's nothing precluding increasing a rent. Otherwise, to my knowledge, I haven't seen anything.
Yeah, the thing I like to point out on this piece is that if you can't unilaterally increase the rent. You can propose to increase the rent, and that needs to be agreed to either verbally, in writing, or by action. They would need to pay you the higher rent or agree to it in some manner, whether in writing or verbally. So a landlord just sending out a statement that says, your rent is $1 million next year isn't useful because it's never been agreed to. And I know that's an extreme example, but that's where the principle goes to. So it does need to be an agreement between the two parties, just like the initial agreement had to be between both the parties.
Great. So that's what we've got for written questions for now. I think to keep us on track, we'll just ask the panelists and if they have anything else they want to share before we start closing out with Gary and some survey questions for the group. Anything we missed? Anything you really want to leave landlords with?
I'll start. I have plenty of shameless plugs. We have lots of things coming out for landlords. I've said it 10 times. We have the Landlord Ambassador Program. That's a one-on-one service to go over your business practices, address some basic questions. Not an attorney, but some great education and materials. We would really like to see more people engaging in the classes we're offering. Now that we're virtual, there is no real cap on those classes, and it's a great opportunity for peer sharing. We take that information back. Our staff sits on different policy working groups, eviction prevention groups. So the more people we have in there, both learning from us, we learn just as much from you. So please participate in our classes, even if you have before. We're changing and updating that information. And now we're launching a series of 1-hour classes. Next class is going to be on the 26th. We're focusing on fair housing. We'll be talking about sexual harassment, service and emotional support animals, criminal background checks, and tenant screening. We have a lunch and learn on the 2nd from 12 to 1 that's going to focus on financial resources for landlords specifically. And then you can call that hotline from 9 to 1, Monday through Friday. There's somebody there to talk to. We might not always have a solution or a perfect answer for you, but whether it's your tenant or you calling, you're going to hear the same information. And you can advise your tenants to call as well if that would help reinforce any next steps that you're trying to take, or just have some accurate information shared to either party. And then we launched a YouTube channel available both in Spanish and English. And if you have ideas or requests for topics that you're interested in, please send those our way. We're pretty adaptable, and we're here to serve you. So let us know what you need. If it's something that we can do, we're going to come up with a way to do it.
I can jump in and give a closing thought. I think my best advice would be to make sure that when you're doing whatever actions you're doing, that you're focusing on from a business perspective and not trying to think about things in a personal manner. It can feel very personal. I understand that if folks haven't paid their rent and you feel that they're responsible. But if there's an offer made that can help you move forward and get you off into the future, hopefully when we're not in a pandemic anymore, it's probably going to benefit you to have a tenant there. And not go off into the abyss of Lord knows when someone is going to move in who will have strictly perfect finances going into the future. So I think it's a good idea to think everything from a business perspective of how is this going to go? How is this going to benefit me in the future? Can I get a little bit of rent or some portion of what's due in the past, and move on when hopefully people's health and safety is not so much at risk.
I guess I'll conclude by saying, I guess I challenge the whole panel to be the city that actually proves that we can just be a housing industry and that there don't need to be sides to this at all. And that if we work together, we can be stronger and we can show the rest of the state how it's done. The courts are getting there. It's certainly, what Gary's done in code, the percentages in Rochester are outstanding. I don't want to see any of that deteriorate because our landlords can't keep things in motion. So as much as having compassion and understanding for tenants, also recognize we need to foster that landlords are not slumlords, that landlords are not racist, and try and make it so that landlords are property owners, get away from that landlord word and recognize they're providing a service that is necessary for affordable housing to exist in the city.
I'd echo all those things, and I would just say that, you know, for us, it's really going to be about preserving housing. So we're going to be trying to make back payments in any situations that if it's regulatorily possible, we're going to be trying to make rent payments and keep people housed. And so encourage your tenants to apply if they have issues, help them through the issues, call us, you know, get their permission to seek information about their pending applications and get the information and help them get through the process if they need that, because we are trying to prevent evictions and get cases open and get money into landlords' hands that tenants owe.
All right, super. Thank you guys so much for participating in the panel and providing your expert knowledge on topics that are continuously evolving and quite complicated. We really appreciate it, and we encourage the attendees to reach out to your organizations if they're interested in accessing services. And again, we'll provide information to the attendees with that information. So big thank you, thank you, thank you. All right, with our remaining few minutes, we're going to have some closing remarks from Commissioner Gary Kirkmeyer, and immediately following, there will be a poll, a series of polls asking about your experience today, and hopefully you enjoyed it.
Thanks, Henry. Great job. Before I get to closing remarks, I just want to make sure that people understand the mayor was scheduled to join us today. She fully intended to join us today. If you could imagine how busy the mayor's calendar is in a non-COVID environment, it is extremely complicated and more crazy in COVID. Things are changing rapidly every minute of every day. And she does get pulled in a lot of different directions, but make no mistake, this mayor, I've served 5 mayors. This mayor really passionately cares about this topic of health, housing, and our relationship with our business owners that avail housing to our residents. So she would have absolutely been here if she could have at all, if it was possible. Second, I want to make sure that and reiterate that we will answer the non-legal questions. So any questions that we weren't able to get to today, we will form a document and post that document. Probably won't take us much more than a week. So look back on the website, the Landlord Summit website. And again, we're not going to try to tackle the legal documents. We can't provide legal advice, but we'll tackle every other question. So in closing, I want to thank you again for joining us today. We hope you found value in the topics discussed. We welcome any feedback you have on how to make this event more useful for you and your operation. After all, this event is all about you and your operation. We especially hope that we were able to provide some appropriate guidance to navigate through this challenged and unprecedented time. I want again to thank our panelists, our presenters, Henry, fabulous job, Jill and Ann. This could not have happened again without their assistance. In closing, I'll echo some of the things that I know the mayor would have remarked on. These are very difficult, challenging times for you as landlords. They are very challenging times for all of us. And so we continue to do what we can to help both you and the tenants get through this. And we know we will get through it, and we're going to be an even stronger city as a result. I want to thank you for all you do for the residents and neighborhoods of our great city, and wish you a happy and good rest of the week. So goodbye for now.
Thanks, Gary. And thanks, everyone. You'll see a series of 3 polls pop up now. Please answer those before you leave us. This will help us better improve events like this in the future. The next one. Great, thank you for your input. Last question. All right, well, thank you folks and for staying on, providing your feedback. And I'm really glad to see it looks like 82% of people found something today that they can immediately use to address whatever issues they're facing. All right, thank you everyone. We're going to end the session. Again, please look for more on the webpage, cityofrochester.gov/Landlord Summit, and where there'll be a recording of this session and all the materials referenced and some additional follow-up materials. Thank you and have a great evening.